My lord, may I be permitted to mention, my lord? Yeah, urgent motion. Yesterday, my junior handed over the sleeve. What has happened? Urgency, without saying any urgency. Urgency is that, my lord, is pertaining to second SLST 2025. Now, School Service Commission, my lord, in the rule, my lord, there is a stipulation for 10 marks for teaching experience. But in the advertisement, there is a, in online form, there is a earmark saying that the whether you are a teacher of any sponsor school in the state of West Bengal, but rule is saying otherwise. Rule saying any teacher, any in-service teacher, she can put for 10 marks. She can enter it. Now, my lord, my petitioner filed the writ petitions seeking 10 marks. Similar coordinate bench of this honorable court already decided the issue, give direction upon the School Service Commission to allot marks in respect of certain petitioner. Now, my lord, my urgency is that, my lord, if the result is published in the meantime, then my petition will be.
Meantime means applications are just going on.
No. Examination has already been over.
Examination is.
Yes. Any time, my lord, result can be published.
When did the examination take place?
In the month of September. 7th
September.
September and 14th
Yes,
September.
and then October was holidays.
I filed the writ petition during the period of vacation bench. Now, my lord, I mentioned the matter last week. Last week, my lord, the Honorable Justice Shogota Bhattacharya pleased to give direction. The matter will appear on 3rd. But due to change of determination, matter could not appear.
Yes.
That is the situation in my matter.
It will appear in the list.
Well, any day, my lord, let
it appear, then give notice to your other side.
But I with notice I am mentioning before your lordship.
All right. Let it appear at least. Number 10 not listed.
May I mention my restoration application? Lordship was pleased to dismiss my content application. Restoration of that.
Yesterday I took up many applications.
Yesterday it was too overcrowded. That is why I did not want.
Not at all overcrowded.
It is not having a heavy dimension right now, Lordship. Any day, my dear. Restoration of content.
I can understand. All right, give. Let us see when it will appear.
For upgradation, family pension already sanctioned by the authority, but due to court pending.
Please wait. No.
Court has already decided that the family pension. Supreme Court decided.
Please wait. Please wait. Not today. You mentioned I'll take up pension matters on a day. Do not mention. Yes. Not in the list. There was change of determination. What is the matter about? Compassionate appointment. Yes. Yes. There is already an indication in the list. Pension matter. Please write the number and give. So that.
6 transfer matter. Transfer.
Lordship, may I be permitted to mention?
Transfer. May I?
Stop, please mention the heading. Otherwise, it will be easy for them.
It's indicated.
Extremely urgent matter. This paying for the unlisted because the School Service Commission going to publish the result on the coming Friday. Supreme Court observed that the unattended teachers should be given the first priority. Till date, there is no such notification. So that's if the result will be published, the matter will be infectious. Kindly, because they are including some marks in the with the result.
Yes.
And if the result will be published,
Yes.
there is no such notification. How the priority should be given to the unattended teacher.
Yes.
That's why this is a very urgent. Kindly in the chamber now, kindly take it up on the Thursday.
Thursday?
Yes.
No, tomorrow is a holiday. Then how can you solve? How will the other side come prepared? You file it in the department, give the number, it will appear next Monday.
In the meantime,
nothing will happen in the meantime.
Inclusion in the list, Honorable Justice Shogota Bhattacharya directed
to the department, get the number, hand it over so that it will appear in the list on Monday.
Honorable Justice Shogota Bhattacharya directed to matter appear today, my lord. Matter is urgency that my lord petitioner is 80 years old, my lord.
Petitioner is
80 years old. His name was changed for PPO, my lord. Extremely urgent.
Changed the name.
Petitioner's name only.
Changed it. You changed it yourself.
Yes, my lord. Only directed to PPO, my lord. Changed.
In the new name.
Only caste, my lord.
Caste.
Yes.
After retirement, caste.
petitioner.
Mention afterwards,
Lordship,
not
may I
now.
be permitted to mention one urgent matter, Lordship? The petitioner was a assistant teacher. She retired on January 2025. She is not receiving any pension due to alleged overdrawal amount. Petitioner's husband is really sick, my lord, diagnosed by cancer.
No. What you want? Where is the matter?
It is an unlisted motion, my lord. Kindly.
Unlisted means where is the matter? When did
20
you file it?
2024, my lord.
So from 24 it is pending. What did you do for so many months?
It was mentioned before the preceding bench, my lord, but Honorable Justice.
Anyway, yesterday I took up a lot of matters. You give, I'll see what is to be done.
Kindly.
These two identical matters were heard on 29th, my lord. It was directed to appear today, my lord. This pertains to, my lord, 10 marks of teaching experience. Just now, Mr. Chatterjee mentioned before your lordship, my lord. This was heard and directed us to add party, the Union of India. We have added and served copy also. My lord, kindly, well, I have annexed the orders passed by the previous bench also.
Okay, we'll give, we'll see. Two new motions. It will appear.
Lordship, may I be permitted to mention one contempt application for inclusion in the list?
Yesterday I took up a lot of contempt matters. Do not mention now.
Lordship, the order was passed on 3rd October 2023, Lordship.
May I be permitted to mention a matter, Your Ladyship?
You can take the microphone up. You are not required to bend. The microphone moves. Yes.
In the last order, the
What
matter
you want, please tell me.
to enlist the matter.
To enlist the matter. Where is the matter now?
It was directed to be listed in the monthly list of November 2025, Your Ladyship, but it is not listed in the monthly list.
Yes.
Kindly enlist the matter. It's really urgent.
Give the slip.
Lordship, the contempt application was filed in the year of 2024, Your Lordship. It was mentioned earlier, Your Lordship, but the matter has never appeared in the list. Your Lordship, kindly take up the...
For 1 year you mentioned and the matter is not there in the list.
Lordship, the advocate on record has mentioned the matter earlier.
Then what happened? Why didn't the matter appear? For 1 year?
Lordship,
No idea?
Lordship, this matter has never appeared in the list. Lordship, kindly take up the matter, Lordship.
Was it mentioned? Did you take up any steps for getting the matter heard? Or all on a sudden you come up and say that
Your
1
Lordship,
year
this
the matter was
mentioned.
If the matter is mentioned, the matter will appear in the list.
Your Lordship, this matter has never appeared in the list.
I may permit you to mention one matter.
Gratefully.
It was supposed to appear today, my lord. It was taken up by coordinate bench and state respondents was directed to file a report and matter was directed to appear in the...
Alright, you give it will be seen.
My lord, this matter, I am here to mention this matter for inclusion in the list. It was supposed to be in the list of November monthly list, but it wasn't.
Give the number.
My lord, mentioning matter for inclusion, it was supposed to appear today, my lord. It was directed by Honorable Justice Shogota Bhattacharya. The District Inspector of Schools was supposed to file a report.
Alright, give.
My lord,
Great one, my
PF to GPA matter, my lord. Matter already listing, my lord. Combined month is 100, 300. Kindly want upgrade.
Give the number.
Okay.
119th of
PF to GPA. Same matter.
Give the number. There is already indication in the list.
Lordship, 119th of yesterday's list, monthly list. Lordship, this matter, I have no Lordship objection to move this matter, but Lordship, it appears from the records that your Lordships appeared in this matter, Lordship, as for the petition.
119.
Ramarani said.
One 119.
119.
118 of the whole. 119. Ramarani shit. Next day has to be mentioned. To be mentioned on the next day.
To mention one original side review application. There's a directive for exchange of pleadings, my lord, which should completed. The matter is otherwise ready for hearing. If the same can be included in the list.
Call the list, please.
I thought I would wish my learned other side a birthday, but he's not here.
Why? Did you serve?
Yes, the service is complete. They were there. Outside also is there.
All right.
Your Lordship, I'll just tell you what has happened here. I was not present on the day because I was not in India. I had already indicated to my learned friend that I will not be there, and they had agreed. But I think whatever circumstances, orders were passed for directions. My only problem with the direction, this direction for consideration, is that what they have done is that a time barred steel claim. They're continuously making representation, and then now they are through a writ petition. They are seeking an order for direction, and then this question of limitation will continue later on also. I just wanted a clarification with regard to the last order, that the questions with regard to limitations are kept open.
Paragraph number 4 clearly mention all points are left open to be decided.
Yes, Your
It
Lordship.
includes limitation.
But Your Lordship, what has happened here is that entire, because Your Lordship, there is also a recording that we have not made any submissions.
Yes, if you
Your
have
Lordship,
not
my
made, you have made.
Your Lordship, my learned junior was there, and he had, because we had indicated to the other side also, and they had agreed that the matter will not be taken up that day because I was not there.
No, it doesn't matter. It's not a matter of the parties agreeing. If
I
that
understand.
matter is there,
Absolutely, I bow down to that. I bow down.
Called on.
I absolutely
The
bow down.
parties appeared. Respondent number 2's appearance I can see.
I bow down to that, Your Lordship.
Yes,
But
come.
Your Lordship, all I wanted
The
to
petitioner
indicate
brings
was
for recalling of the order dated 25th August 2025. Stop. It appears that the said order was passed upon hearing.
So Your Lordship may just consider then this judgment, which then I will have to show a judgment and all. All I wanted, that's why I wanted a clarification, that question of limitations, because my submission that these are time barred claims, only that much may be added. That's all that I wanted to have. My submission is that these are all time barred claims with continuous representations.
Recalling and or modifying. Recalling and or modifying the order dated 25th August 2025 passed in the writ petition. Stop. On a perusal of the said order, it appears that the same was passed upon hearing submission made on behalf of all the parties, including the applicant. Stop. Direction was passed upon the authority to consider the legal representation filed on behalf of the petitioner. Stop. It was specifically mentioned that that the court did not enter into the merits of the claim of the petitioner, and all points were left open to be decided by the authority at the time of consideration of the representation. Stop. Learned advocate representing the applicant stresses on the fact that the claim of the petitioner is a time-barred one. Stop. Whether the claim is time-barred or not will be decided by the authority at the time of consideration of the representation. Stop. The court is not entertaining the application filed by the petitioner seeking recalling/modification. The application stands dismissed.
Only Your Lordship will then permit me 2 more weeks to finish the consideration portion.
My lord, this application was filed to escape contempt, nothing else. And my lord, will kindly record. My lord, one thing, only one thing. My lord, this application itself is barred by limitation. My lord, only one small prayer, lordship, kindly records that we dispute the fact it's a time barred claim, because conveniently the fact that this they held a meeting with us to decide the issue was on 6th May 2025. I filed my writ petition in July 2025. Completely misconceived submission.
Of the claim being time barred is denied and disputed by the learned advocate representing the writ petitioner.
Your Lordship will only extend them for...
No, nothing.
Denied.
Yes, for...
Grateful.
Time for the contemnants. Copy it.
Final order after making the arithmetical calculation of the tax payable. Final order?
Probably the junior has been served. If my learned friend says that he has not been served,
No, I've served. I've been served.
So the order has been complied with?
No, there are 2 points. One is the refund part. On the refund part, my lord will kindly
From the
see.
calculation, did you check up and see whether the portion of refund is mentioned or not?
They consider there is refund, but they say this order has not been appealed from. My lord's order has not been challenged.
No, it's all right.
They say the issue is pending before the Supreme Court.
Which
Even
issue?
the issue of either set off or refund.
Paragraph 3
That is a defiance. My lord, This is a decision that even an erroneous order has to be complied with. A division bench decision of my Lord's Court.
I'm not saying it's an erroneous
Then,
order.
then
My learned friend is
this order has this order of my Lord this order of my Lord has not been varied, modified, discharged, whatever. So is it open to the contender to take this plea?
I accede to
Supreme Court has, my Lord, in Abash Abashan rejected that prayer. Again, appeal is filed, my Lord. Kishan Johar. That is pending in the Supreme Court, and this
and the
plea
issue is the same over here. There.
How can this issue, well, they take this point without assailing the order? The chief manager revenue cannot, well, equate himself with the division bench of this court.
I'm not doing that.
That's what he is being doing. This is defiance. This is contempt.
Two things come
The
up.
language of the order, my Lord, the tenor of the order.
Two things come up.
Show me the order of the court.
My Lord's order is at page 30.
Of the contempt application.
Yes, and 31 is the refund portion.
Shall positively be refunded. The authority has
that in appeal. And so far as the other plea is concerned, I accept the plea that may be pursued by way of a writ petition.
The order passed by the chief manager within bracket revenues / south AMC. Is there a date of the order?
No, this order is undated.
Yesterday, no, it was given.
Filed in court on today.
Yes, undated order of the chief manager revenue at the placed before the court today by the learned advocate representing the alleged contemner.
Was served, my lord, just
no longer alleged.
It was served on them.
It's no longer alleged.
কি দিয়ে শুরু করলাম? Has been placed before this court. ঠিক আছে? Paragraph. At the time of disposal of the writ petition on 7th March 2024, direction was passed upon the aforesaid authority to consider the legal representation after giving opportunity of hearing, and if any amount is found to be paid in excess by the petitioner, the same to be refunded at the earliest. Paragraph. The chief manager revenue has made the necessary admitted that certain amount has been paid in excess by the petitioner. At the same time, the authority has not refunded the excess amount on the plea that an identical issue as to whether the excess amount is to be paid by way is to be returned to the SSE by way of refund, or the amount can be set off from the subsequent bills to be raised by the authority is pending consideration before the Honorable Supreme Court in the matter of the Kolkata Municipal Corporation and others versus Rohan Jhawar in SLP within bracket criminal.
CRL. Well, division bench's order, these have to be
Number 23388-23390 of 2024. Stuff. The direction upon the authority to refund appears to be a mandatory one. Stop. There was no direction upon the authority to exercise choice or discretion as to whether to refund or to set off the excess amount paid by the SSE. Stop. The order of the chief manager takes note of a further order passed by the Honorable Supreme Court in a similar issue in the matter of Kolkata Municipal Corporation and others versus Abash Nibash Private Limited and others, wherein the Honorable Supreme Court was pleased to dispose of the special leave petition by directing the corporation to refund the amount paid in excess.
This is the very next page, madam.
Stop. Next. As on date, the issue appears to have been set at rest by the Honorable Supreme Court in the matter of Abash Nibash within bracket Supra. Accordingly, the authority ought to refund the excess amount paid. Stop. The matter of Rohan Jawar within bracket Supra is still pending consideration, and the Honorable Supreme Court will pass direction upon the same as and when the business of the court would permit to do so. Stop. Today, the order of Abash Nibash within bracket Supra holds the field, and the authority ought to act in accordance with the same. Stop. The contempt application.
So one thing, madam, one thing. But the other issue, that I'll pursue by way of a fresh writ petition.
Whatever. Whatever. That is, the court is not interfering.
Kindly at the line. Kindly seize the second paragraph.
The contempt application is made returnable on 17th December 2025. Stop. A compliance report shall be filed by the alleged contemptor on the adjourned date. Stop. As regards any other issue in the order of the chief manager, which the petitioner may feel aggrieved, may be agitated by way of fresh petition.
Grateful, man.
Grateful. So,
Item number 5. Lordship, the item number 5, I have been requested to appear in this matter. Lordship,
on behalf of the petitioner?
Petitioner.
Last occasion he is not.
The name of the alleged contender also has been incorporated wrongly. It will be Mr. Pankaj Sarkar instead of Pankaj Sarkar. It has been Pankaj Datta. So, Lordship, I am praying for let a further copy be served and liberty to correct the cost item.
Serve means you will serve.
Lordship, I will serve, but Lordship, liberty to correct the cost item.
Yes, that I have followed. Has the order been complied? Any idea?
My lord, your lordship has to be pleased to not include my name because the depending upon the service.
All right, so it was
Name
not
is wrong,
served.
so I am here to assist your lordship. The name is wrong.
All right. Please come. Learned advocate appearing on behalf of the petitioner submits that the name of the contemptor has been wrongly incorporated in the cause title of the writ petition. Ke correction korbe? Leave is granted to the not leave. The department is directed to make the necessary correction. Stop. The learned advocate for the petitioner is directed to give the proper name of the concerned respondent so that the same may be incorporated in the cause title of the contempt application. Stop. Let copy of the contempt application be served upon the contemptor. Returnable on 10th December.
Yes.
But fresh wakalatnama is required to be filed.
Advocate and record same, just I have been instructed to appear.
Today also I am not appearing. And these are three. It's all right. Grateful.
Achha, I contempt
I am for the petition. Page 33, blood, it's that matter where
For the alleged contempt.
undertaking given before the blood on
No need to place the matter. My instruction is the relay authorities are in the process of compliance of a lordship's order. Kindly give us only 2 weeks time to file the compliance affidavit.
But my learned senior friend, blood, your lordship's order is of 2 parts. First part is blood, page 35 of my lord's brief, the operating portion. First part, they will have to vacate the premises within a period of 90 days from the date of your lordship's order. That expired on 7th of August 2025. Other part, your lordship has left them free. If they want to acquire, they being a requiring body, if they want to acquire, they can give access to that. So far as regards the first part is concerned, that is over in August 2020. So what part my learned senior friend is
I'll pray before.
It will happen after 2 weeks. He says he'll come up.
Yes, with compliance affidavit.
With a compliance.
We are in the process of compliance. Kindly consider this time limit.
Alleged contemptor submits upon instruction that the authorities are in the process of complying the order passed by the court. A fortnight's time has been sought for. On such prayer, release the contempt application once again on 25th November 2024. An affidavit of compliance shall be prepared and circulated prior to the adjourned date. Service is taken on record.
7, my lord, this is my application, this is my affidavit of service. I have served copy of the contempt application. However, my lord, the only development which has happened, there is an order direction passed upon the competent authority under the West Bengal Apartment Ownership Association Act, my lord, to consider my prayer. If your lordship be pleased to recollect, there is a...
Served?
Served, my lord.
Nobody is appearing?
My lord, I believe I have been informed by Mr. Samonto that he will be appearing, Joyanto Samonto, my lord.
Where is he?
Lord, I do not know, my lord. I have even served a copy because I have been contacted by him to get a copy, get hold of a copy. I have already served a copy subsequent to the service upon the competent authority. My lord,
What do I do? Do I adjourn it?
My lord, kindly adjourn it if a further direction may be passed, because what has happened subsequent to filing of the contempt petition, there is certain development. There is a notice which has been issued now. However, there is a direction that if your lordship be pleased to recollect the matter of Mita Doss.
Whatever.
And
it's not possible.
Since the patent petitioner are on the same footing, there's a direction to consider the representation by giving fresh opportunity. However, a hearing has already taken place. No opportunity, no show cause has been issued upon the association. If that
Please come and appears on behalf of the alleged contemptor despite service. Affidavit of service filed in court is taken on record. Let further notice be issued. Release the matter on 18th November. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
Great.
Well, this is my application, my lord.
Yes.
This is the matter where we were harping day in and day out.
Yes.
My lord, kindly see the last order that my lord was pleased to observe. That is the 10th September 2025.
10th September to the contempt, can I ask you to contempt test?
The competent authority
shall decide the matter. Now, we have made a representation to the competent authority, my lord. Now, unfortunately, they have issued us a letter. I will show, my lord. We have given it on 15th of December itself. Now, after receiving this, they have written a letter, my lord, on 24th of October, saying, my lord, nothing to do whether this is. But may I just hand over, my lord, with leave. This was our application letter, and this is the reply letter. I'm sorry, I couldn't.
Yes.
Well, kindly see, and to the reply to the 22nd October 2025 letter, we have written, my lord, a composite reply without
again a reply,
because they have asked certain questions.
Oh,
Well,
what is the query?
Question. What is the question? Now, kindly see, upon scrutiny of the documents submitted from your end, The following observations have been made. As per the statements annexes E and F, a total quantity of
such and such tons of stone material
produced boulders has been shown as dispatched in 244 decks during November 2023 to March 25 from RCSC. However, as per the railway receipt details, actual quantity dispatched in so and so tons. Therefore, valid documents regarding the mining rights and royalty payment of the balance tons may be submitted. Now, this has got nothing to do whether I was extracting. Why? They say these tons, I have to submit royalty payment. My simple answer, my lord, which I have written here is, kindly see the predicament of the railway.
No, tell me what.
My lord, these are, my lord, stand dust.
Listen, it says that your figure is 4 something, their figure is 8 something. How does this discrepancy take place? Because the rakes are allotted by them.
Yes, kindly see what is happening. I have said that I have supplied stone materials which is more than quarter of an inch of a particular quantity, right? Which is around 4 tons. They say that no, as per the rakes we have supplied, you could have carried 8 plus. So you have not
could have actually
carried.
Yes,
actually carried 8 plus. So you have defaulted on paying royalty.
Yes.
Now, let's assume I am the worst person on earth. I will pay royalty to Union of India or state government. Answer is state government. There is not a single allegation against me by the state government. Why? Because the state government apparently knows the law that these are stone dust. Now, Malad, I will show from the documents submitted by the railway authorities, complete rakes, Malad, complete rakes of 44 bogies. I have supplied stone dust.
Anyway, next one, serial number 2.
Number 2. No, I have given the documents Malad here. Next, number 2.
Purchase bills of stone boulders.
Malad, kindly see the
no
total
GST
ignorance of law here. Total ignorance of law. They say United Stone has supplied you the materials. You have to furnish GST invoice from United Stones. Now, the basic principle is I am a GST holder. United Stone is not a registered GST holder. According to the knowledge I have known, how on earth a non-registered GST holder will supply the GST invoice? I don't know. I simply don't know. I have stated that as per section 9.2 and 9.3, it is not required. I have stated that here. Number 3. Kindly see, my lord, they want voluminous documents of the entire dispatch bill, which will go, my lord, at least more than a human size. These documents are lying in there. These are lying with the at site. The site superintending advisor, whatever, my lord, that person knows the entire thing. Now, a person sitting in an AC office in Calcutta can write anything. But this does not show, or prima facie does not show, that I have purchased the materials from United Stones. Because they say you have purchased more materials, where is the royalty? There is not a single allegation. What was my statement? That I was purchasing and there was a typographical error in the tag number. Malord has rightly pointed out and correct and indicated us, Malord. There is not a single scope of interpretation that I am not doing this. Because my lord's order is absolutely clear. So, my lord, after receiving this, we have given a composite reply, my lord, showing that rakes, total rakes, when the total rakes are supplied with stone dust, separate documents are given. When stone dust are being supplied, because stone dust today is somewhat, these are, I mean, it's like gold dust also. Usually, previously, my lord, in my lord's grandmother, there had gold dust, nobody bothered. But now, gold dust is also very important. We get gifts, my lord, of gold dust. So this is the piece of my lord. We can't fight tooth and nail with this person because they are adamant. But there's a change of, I hope there's personal. We have given a reply, composite reply on 2nd November, my lord. Let them take a call and within a particular time frame, let them decide. because this apparently, in my humble submission, my lord, does not justify withholding of recs. So this fight may continue at the.
When did you submit that?
I have submitted the first letter.
22nd October is their communication.
15th October. I have given a copy.
No, 15th is previously, 22nd is
Oh,
there.
this is ballot. This is a composite ballot. This we have. I am giving a here and now a copy also.
All right.
Just I received this copy, Your Lordship.
No, but then it was supplied to your officer. It is not you. It is not to be supplied to you.
My lord, just to keep update to myself here, my lord. My lord, my learned friend is just going to net. My lord, let me submit, my lord.
Yes.
My lord, my learned friend is again misleading, Your Lordship.
Yes. All right.
This case is not a stone dust, Your Lordship, and this royalty and all these things.
This is his submission. He must correct himself.
Please appears that
You are again. You are mentioning, Your Lordship. You are mentioning as royalty. That is not at all royalty for that.
the court on
You are again misleading, Your Lordship.
2025. A representation was filed by the petitioner on 15th October 25, and a communication from the authority dated 22nd October 2025 was made. Stop. In furtherance to the communication of the authority, the petitioner submitted a composite reply on
2nd November.
2nd November 2025. The response of the authority is awaiting. Stop. Hearing of the contempt application stands adjourned till 2nd December 2025. Stop. A decision shall be taken by the authority and placed before this court on the adjourned date with advance copy to the petitioner.
Deeply. And I have handed over a copy also.
Achha, a copy of the composite reply by the petitioner submitted by the petitioner before the authority on November 7th. Second was a Sunday. Are you sure?
That's yes, by email and
by email. 2nd November has been handed over to the learned advocate representing the authority in court today. All right. Oh, you were there in that matter. What happened?
We have taken steps for, we have issued notice to them for appearance. We have taken also steps for of so-called notices and all these things. And tomorrow is the date fixed for hearing.
যেখানে বললাম না যে ও আসেনি ওটা চেঞ্জ করুন তো লিখুন যে লার্নেড পুরো কেটে দিন লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং অন বিহাফ অফ দি contemptor submits upon instruction that steps are being taken to comply the order passed by the court.
My lord.
In view of such submission, hearing of the contempt application stands adjourned till 16th December 2025. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
Grateful also. Well, I was stuck in another in a contempt.
Keep somebody handy so that it's not possible for you.
Junior also is stacking another.
Keep a battery of juniors. Only 1 and 2 will not do. There are so many. Give them some work. They will also learn.
The thing is this, blood, if I engage blood, the burden will come automatically upon me.
Upon you.
Yes, with Jasi Bhatta, Hirma Bhattaji once asked, why have not instructed your junior? Blood, I am a bad senior. That's why I have not duly instructed my junior.
No, then don't do this. Please.
That's why I have not.
You keep more juniors. They will also get work and you will be relieved because you cannot appear in so many courts at the same time.
Court 28, well, I have a contempt application.
SP Centenary building, then Centenary, then the main building. It becomes difficult.
From 7:59, I have to, sometimes I have to rush not to leap by stairs.
Yes, yes. Take care. Do not fall down. All right.
Grateful. Grateful.
My lord, I am for the petitioner, my lord. On the last occasion, your lordship took up the matter, my lord. Considering the urgency, my lord, your lordship thereafter directed a report to be filed, another report, and fix the matter today, my lord.
Other side, not here. See, Mr. Shamanta, same thing.
My lord, my
cares are required. Please train them. so that you leave behind a legacy. Otherwise, see,
Lordship can remember nowadays the juniors are more interested in having fees, not the matters.
I understand.
When the fees will be reimbursed or disbursed to them, that is the only motto, not the files, what is inside the file.
Listen, you have a considerable amount of practice. You had. So your hunger is less. For them, they are hungry. You need to feed them. You cannot expect work from a hungry person. So the state should also change its modality as to how to pay the juniors so that they get interest.
In the affiliate side, today we are 1600 plus.
Juniors.
Total. The advocates, state advocates, imperial advocates are 1600 in the civil side.
And is everybody getting work?
Yes.
Even then, the state is not represented. They are not coming with instructions, waiting for the seniors.
Somebody is saying, whenever I call over telephone, I'm in Howrah Court, I'm in Sialda, I'm in Alipur.
Do not keep them in the panel. Why keep them?
They are member of the High Court, but
maybe members, but if they are practicing somewhere else, it's not possible.
they are practicing here. They for their own work, they went to that court, they will not come on.
No, it becomes very difficult. If the state council, even I have had occasion when the council said I was engaged in some tribunal and somewhere. But this way, the court cannot function. You all have to engage or keep persons in the panel who are dedicated to the High Court.
What is much more important, the dedication.
Yes. Otherwise,
from inside, not from
true.
You cannot impose them.
And that is only because you had a petitioner's practice. It is only because of this. You can understand the pains and the agony of a litigant. One who appears for the... Yes, this is the reason. If you are there only from the very first day for the respondent, you do not get that connection with the litigant. Till you are connected to a litigant, you will not get that feel and the pain.
Yes, my lord. My lord, on last occasion, your lordship directed to file a report. So this is the report.
I have not been served, my lord, before your lordship.
Here is the
report,
Yes,
my lord. A very short facts, my lord. These petitioners, my lord, petition number 1 and 2 were given admission in respective medical college through counseling under in-service quota. My lord, the rule is, since these persons are working, if they avail the in-service quota, then they will continue in service. If I do not, then my service will be terminated. I will be without salary and everything. So, my lord, I applied. I was found eligible and I was given admission in Shishu Mongol, considering my rank for pursuing MD as an in-service. I have the document, my lord, I will show. My lord, the rule is, on the last occasion I showed, that every year 10% of the existing strength in-service tier will be issued. Now, my lord, existing strength must be, my lord, constant, because for the last 3-4 years, there was no recruitment. Now, my lord, the previous year, this year, my year, the existing strength, they have said, according to the existing strength, 333 in-service quota will be issued. Now, my lord, there are 3 cadres under this. One is medical service. One is...
No, that you submitted. I can see one recording that there are 333 seats combined for all cadres.
Yes, all cadres.
Right.
Now they have they have bifurcated. There is no rules. They have bifurcated that 12% of the total 333 will be for medical education service, and the rest will be for medical service and for medical administration. So, my lord, 12% of 333 roughly comes to around 40. So, admittedly, 293 odd will be for medical service and administration, and 40 for the medical education. That is, they have stated in their report. Now, my lord, in the spiral bindings, my lord, I have issued, for that year, they have totally issued 346 in service, out of which 55 are medical education and the rest is medical service. I belong to medical service. I say, firstly, you cannot bifurcate. And if you bifurcate, then you follow your own rules. If you follow your own rules, then if there are 346, 12% does not come to 55. Then we are the only person left under in-service category.
Check up what the report is today. The resolution of wherein category decided that 12% of 333 seats, that is 40, will be reserved for the medical education cadre.
Yes.
2 seats reserved for PDCET. Remaining, that is 291 seats reserved for the health service and PHAS. Administrative service. And the selection will be based on the NEET ranking. Copy of the resolution is also annexed.
Now, my lord, take this as true, my lord. Take this as true. Kindly come to once, my lord, the spiral binding that I have given to your lordships. Kindly see. From page 1. The calculation, in fact, comes more. My lord, page 1, your lordship had come.
Yes, page 1.
My lord, kindly see the first line. The undersigned is directed by order of the governor to say that the governor has been pleased to permit 40 medical teachers, means medical education service. My lord, this is 40, means 40 is over. They say number of TA for. Now come to next page. My lord, page 3 are the persons who have been given their details. Now page 7, my lord, kindly come.
Yes.
See, my lord, second line, 12 medical teachers, it comes to 52. So they are not following their own rules.
Oh.
There are many, my lord.
One minute. Page 1, you said 40 medical teachers.
Now page 8, my lord, 7.
That is 8th May.
8th May.
Yes.
12. That means it already comes to 52. There are many more, my lord, I can show from every page.
So that means they are not following their own resolution.
First, what happening because of this, my lord, we too belong to medical service, doctors. We are being left out. Now, my lord, they are saying total tier they have issued 333. My lord, this shows, if your
calculation shows it's much
346.
How is this discrepancy coming?
Kindly takes my report once. He may say, my lord, he calculated, but so far my report is I cannot, my lord, whatever he says, my lord, he says.
No, whatever he is saying is on the basis of records.
No, my lord, kindly takes my report once. My lord, it has been categorically held and mentioned, my lord, that entire transparency has been made. My lord, kindly takes paragraph, first page, paragraph 4, my lord.
Yes.
My lord, kindly see the last portion.
Yes.
Accordingly, on the basis of the said resolution, that is the resolution that has been shown, my lord. Tier orders were issued separately for the session 24-25 by the Director of Health Services, placement of trainee of so-and-so eligible so-and-so. Tier order was issued for 4 eligible in-service so-and-so candidates in pursuance MHP course in the month of June. 24 eligible candidates so-and-so. Thereafter, unfulfilled seats reserved to PCDT candidates. So, tier orders in favor of 292 eligible in-service candidates were West Bengal Health Services and Administrative Services cadres were issued from the end of the Director of Health Services out of total 333 allotted seats for the season 24-25, maintaining complete transparency. Thereafter, my lord, it is pertinent to mention here that the last eligible TR candidate WBHS and Administrative Services cadre is Dr. Pratik Das, having All India Net PG ranking 1,67,000, appearing serial number 291 of the memo state nodal officer dated so and so. Whereas Dr. Priyanka Shahana, that is the petitioner, and both the petitioners appearing serial number 297 and 321 respectively of the said memo secured All India Net PG ranking 171,904, 201,839 respectively.
That means they are far below in the rank.
Far below in the rank.
Not a question of rank, my lord.
And my lord, kindly appreciate one thing, my lord. They are under they are the doctors. They are not under administrative service. Or
they admit that they are practicing doctors.
And we have so far the TR tele reserve is concerned, that is confined to up to, my lord, that I have mentioned, my lord. Last impaneled candidate number is, my lord, 167
291. Serial number 291.
My lord, what I have submitted has not been replied to. It is 346, not 333. This has not been replied.
If it is 346, my lord, I assume. If it is 346, my lord, then also, my lord, we have so far.
Then also it has to be 12% of 346.
So far, my lord, the doctor services are concerned. If we consider, my lord, that, well, from the administrative services, we will take 3, 4, 5%, not from the doctor services. So, my lord, we have taken, if it is not, we have taken from the administrative services, not from the doctor. So this is the discretion, my lord. In Rule 9, it has been mentioned, my
My
lord.
lord, may I
The government
place
has the
one
discretion, my
paragraph
lord,
of their
to
report?
take this, my lord.
My lord, may I place one paragraph of their report? Now they are saying something which is not stated, which is
No,
stated
not
is
something,
contrary.
my lord. I have
My
just
lord, if
answered
your
my
lordship kindly comes to their first report, my lord, kindly.
Where is it? What is the date?
My lord, first report date is, my lord, 15th July. Page 5, Roman 7. Page 5, Roman 7.
Yes.
My lord, I am reading the entire paragraph. I say that in excess of the powers conferred under Rule 9 of so and so, a meeting was held in order to distribute the total number of declared tiers amongst the different cadres of Department of Health and Family Welfare in presence of so and so, my lord. And a resolution was passed wherein it was categorically decided that there should be a percentage of seats which may be reserved for WBMES, means Education Service cadre, and the House unanimously decided that 12% of 333, that is 46, shall be reserved for WBME. So, my lord, admittedly, they have stated that 12% of the total tier will be for WB education and rest are for service and administration. Now, my lord, the figure is not 333, figure is 346. Now, 12% of 346 may be reserved for education service, but the rest then should be distributed amongst medical service and medical administrative service. This has not been done. Secondly, my lord, I will like to show your lordship two documents from my writ petition, my lord, which are very important. Kindly come to page 187 of my writ petition. Why I say this is a complete arbitrariness, my lord, your lordship have read 10% of the existing strength and it should be constant, it cannot vary. My lord, kindly come to page 187. This is the, my lord, present year 2025-2026. Kindly see the number of tier issued, 453. Next, my lord, page 188. Kindly see my previous year, number of tier issued 489. So how can it this year it be 333? It is no new recruitment. So if it is low next year, so how can it be high again the previous year, the next year? My lord, so this is also arbitrary, illegal. The figure is not the rule says 10% of the existing strength and it should be constant. So there are, my lord, twofold challenge. First, it is not 333. Secondly, it is, if it is 346, then according to their own admission, I should be getting a chance because 12% of 346, the rest should be divided among us. And in their report, they have not stated a single thing about they are still saying it's 333. It is 346. I have shown from their documents.
Mr. Basamalli, calculation is going wrong.
No, my lord, kindly, if in that report, my lord, my lord will kindly take paragraph 4.
Paragraph 4 you've placed.
Paragraph of the report, my page 3, my lord, kindly takes paragraph 3. Paragraph 3. I say that the session 24. Lordship has got it.
Today's report?
No, my lord, prior report. What has been shown by his lordship, my friend. Kindly see, my lord.
Paragraph?
Page 3.
Page 3.
Lord, kindly takes paragraph 3.
Yes.
I say that in the session 24-25 total tier seats allowable 333 for medical officers under so and so. Copy of the said memo. Thereafter, I say that similarly this year also allowable tier seats 453 has been declared for medical services cadres with a memo dated as calculated by the GO. As such, the question of erroneous fixation of numbers of TRC 333 for the session 24-25 does not arise. A copy of that memo dated 7/6/25, that is annexure R4, Millard.
You say 333 is erroneous?
333, Millard. No, they says Millard erroneous. We have deal with that, Millard. What we have said, Millard, that what they said as such, what can you say as such? The question of erroneous fixation of number. This year 453, prior there to
333 is not the figure?
No, this is a figure. They says, my lord, this it cannot be 333. We have said, my lord, this is 333. Everywhere we have said that 333.
But then the documents that are annexed to the spiral binding shows that the figure crosses 333.
But I have categorically asked them what, but they have in my report also it has been.
No, but then if your report and the documents of the authority are
no, my lord, these 346, what it says, my lord. So far in my last today's report also, my lord, lordship will find, my lord,
How
nowhere
can
it has
it
been
be?
mentioned about 346.
Why is it so? This is the query of the petitioner, that the petitioner is harping that it is not 333, it is
So lordship
346.
order also says that you have to answer on that.
Where is the meeting up of the discrepancy?
I so far if it's lordship paragraph 6, my lord, if you take
No, first, have you been able to understand what is the difference between 333 and 346? Why this difference? Why is the petitioner?
I have asked them, my lord.
And no proper answer is there.
They says, my lord, we have said, my lord, that is 333.
This is there with you. You have it. You have it. You make the calculation. The addition comes up to 346. Then how can they say that it is 333? Then the figure is wrong.
All along it has been said, my lord, 333. All along. Even today's report also, my lord, 333.
But the petitioner is annexing documents, and you are not denying that these documents are not proper.
And my lord, in today's report, kindly takes paragraph 6 once. Paragraph 6 once, my lord. Similarly, trainee reserve orders were issued separately for the session 24-25 by Director of Medical Education for placement of trainees, total 53 eligible in-service cadres under so net PG All India rank, which went beyond the stipulated 41 seats remaining one fulfillment resolution. Regarding this discrepancy in number of placement of trainee reserve cadre for the session 25, this is to state that a clarification note from the end of Director of Medical Education dated was issued and submitted earlier before this Honorable Court at Calcutta in complying with order dated
Neither here nor there.
Huh?
A copy of that R4, my lord.
R4, please check up.
R4, my lord. This is the clarification note, my lord. Clarification note, my lord.
10%. They are sticking to the 10%.
And my lord, as you kindly seen, my lord, trainees are 10% at present. There are 3915 approximately faculties are under therefore the basis of 10% quota sanction trainee reserve is 391 for West Bengal Medical Health Services. Following education services. Following are the year-wise MTTR post issued. MTTR allotted financial year 22-62, then 39, then 44. So
No, all right. Then without going into all these things, you check up the number. This 333 and 346. Why this discrepancy is coming in? You please sit with your learned friend and try to understand what exactly he wants and where the shoe pinches. And paragraph 7 of today's note says that the petitioners will be permitted to appear for further counseling for this session 25-26, subject to the condition that they must qualify in NEET PG and secure the requisite rank
My lord, if
within
your
the
lordship kindly
stipulated
comes to page
seats
72, there
of the
something
of the writ petition.
Kindly come to page 72. This is issued by the Government of India. My lord, I have already deposited 5 lakhs. That will also be forfeited. My lord, kindly see third from the bottom, my lord.
Yes.
Third, the security deposit of candidates who do not join the allotted seat in stray vacancies will be forfeited, and such candidates will be debarred from taking NEET exam for the next year.
No, but this is for the allotted seat. If you do not
Yes,
get
I
a
have
seat,
been allotted. My lord, kindly come to page 89. Page 89 once.
I fail to understand. Do not join the allotted seat. Seat is allotted by whom?
By the they have allotted me seat. Page 89. Kindly see. And I have deposited security deposit of 5 lakhs. Kindly come to page 89. My registration is being withheld because I am not being could not show the in-service tier. They are not issuing. They have already treated me as in-service. My lord, kindly see page 89.
Yes.
Right hand side column, second.
In-service quota, yes.
That's Shishu Mongol, my lord. And Shishu Mongol is at second column. I have been allotted. I have given admission. They have given me. Kindly see.
But
On
trainee
counseling.
because of the
Unless
they
I am
have
a trainee
not come.
reserve,
No,
please,
my lord.
please, আমি শেষ করিনি. Unless I have been treated as a trainee reserve, how can I be said to be an in-service? And my lord, admittedly, only 2 of us are left to get a trainee reserve. Everybody else have got that. Either training
Or
yes,
two means the
petitioners too.
Petitioners too who
Because, my
have
lord,
been given the provisional allotment letter.
Yes. Page 89. And because of this, I took admission. I deposited 5
That
lakh
is after
rupees.
counseling.
Yes, after
they have not
counseling.
made because they have not qualified for the trainee reserve because of the sole reason, my lord. They have not come within the zone of consideration.
It is not a zone of
1,70,000.
consideration.
That is the fact.
No,
my lord.
is it your case that anybody who's issued an allotment letter has to be treated as a trainee reserve?
This is not my case.
Then?
My case is, my lord, I have been, because of the certificate of the CMOH,
Yes.
I was issued an in-service quota to participate.
Right.
I participated, I was allotted an in-service quota.
Right.
I, in the meantime, according to the procedure, applied for tier. At the time of issuing the tier, they are not issuing the tier on the plea, my lord, that I secure less rank. The question of less rank does not arise in issuance of tier. My lord, if your lordship only comes to page, 10% কত page? Page 100, my lord, once. Page 100, if your lordship kindly comes, kindly see what is the only consideration for issuance of tier. The bifurcation they have made, firstly, is not permissible. Second, if I take the bifurcation is right, then according to their own resolution, it has to be 12% of the existing tier issued will be for education, rest for us. But in this case, this has also not been followed. Thirdly, my lord, kindly consider, my previous year number of tiers are more.
No, here page 100 it says that the strength of trainee reserve will be fixed at 10% of the existing strength. Now
So,
this
my lord,
existing strength becomes important.
very important, because, my lord, kindly consider, appreciate one thing. Suppose, my lord, in 2000 existing strength is 100, tier issued is 10. If there is no new recruitment in 2001, the existing strength becomes 90. Okay, I suppose there are 10 retirements, it becomes 9. Then even in 2002, my lord, how can it be 110 and it becomes 11? Then it has to be low. It has to be constant with something. It cannot be arbitrary at their own whims.
In paragraph, in this page 100,
My lord, what is mentioned, it has to be substantiated by cogent reason. Mentioning a statement is not at all.
Paragraph 4 of this page 100, my lord. Sponsorship certificate for appearing at PG counseling will be issued to specific numbers of candidates in order of merit.
Page 100?
Page 100.
In order of merit, then where comes the bifurcation comes?
My lord, kindly appreciate what
I have more rank.
This argument was made earlier before the previous.
No, I do not know what was made earlier. Thing is, I can see that a candidate has cleared the NEET PG and she have been allotted a seat somewhere. If she does not join, she will, the security deposit, she is going to be, that will be forfeited. What is it?
It will be forfeited.
And she is agreeable to join.
Yes, I
No,
am.
no, unless and until, my lord, she, because this trainee reserve is based on the my lord, merit. It cannot be said, my lord, there are everyone, my lord, net PG and thereafter counseling they have secured. Now, my lord, the number of the marks and the total number of, my lord, that has to be taken into consideration. The rank, their rank is, my lord, much.
My lord, if rank is in question, I tell you, your lordship, there are
and the notice resolution has been taken, my lord, for the interest of the others.
You cleared that issue. Total strength, it is 333 and 336.
I shall.
And my lord, only one thing, since merit is being talked about, according to merit, I have more rank than persons who have been issued tier in education. My lord, let me finish. Let me finish. It says, My
Other
lord,
cannot be deprived, my lord.
please.
Other
My lord,
cannot be
page
deprived.
100 says according to merit. It does not talk about bifurcation. If bifurcation is there, then I have more.
All along we
My
have
merit
said,
is
my lord, he has
better.
not come with both of them are not come within the.
I have
Tell
better
you
merit.
one thing. Page 2 of today's note. It mentions that the petitioner may be permitted to appear. Right?
Yes.
What about the security deposit? Will that be refunded?
They have to pay that. They have to, my lord. Otherwise, they cannot.
And then they pay.
If they do not get that penny reserve, it does not mean that they have gone. No.
Security deposit, what it will be forfeited? That is what it says.
Can you check page 94 once? Number, can you see, my lord, page 94 once?
Page 72.
94, my lord.
94.
দেখাবে মেডিকেল বন্ড
Execution of bond. Can you text?
Yes.
সেটাই তো আমার
The medical officers of the West Bengal so paragraph 4. Service so have to execute a bond in tripartite prior to proceedings of penny reserve to such effect that they shall serve in their respective cadre or in service to them subject to force for a minimum period of 3 years.
This bond is separate, isn't it?
Yes,
This is a bond, and that is a security deposit.
I have also given the bond. And another more important criteria is they have to obtain the NOC.
I have the NOC.
No, my lord, they don't have any NOC.
I am showing.
They don't have any NOC. Their hospital does not give them an NOC. And date is
Page
already
103.
over.
Page
No,
103.
103 is not the NOC, my lord.
My lord, this is what has been provided. I am not the employer.
Yeah, 103 is not the, my lord, NOC.
This is the NOC. আগের দিন যেটা দিল loose count.
No, this is your
No,
request.
my lord, I am giving the NOC.
Request.
This is not NOC.
This is one of the important criteria for the purpose of penny reserve.
If the petitioners are unable to obtain NOC, they will not get it.
No, my lord, I have the NOC.
Very well. If they have, they have. Please come. Report by the Director of Health Service dated 3rd November 2025 filed in court is taken on record. Stop. The discrepancy between the figures 333 and 346 being the total strength is still not clear. Stop. Next Tuesday, I keep it 11th.
Yes.
Release the matter on 11th. Stop. Further documents to clear the discrepancy shall be placed by the learned advocate representing the state respondents.
And my lord, only one thing, that existing strength should also be clarified because it cannot vary, my lord, from
No,
year to
only
year.
we are confined. Everything is my lord, only.
No, this is the point. No, my lord, this is the point I have taken. This is the point I have taken.
Which is beyond to his scope.
My lord, I have taken this point in my writ petition.
Let the discrepancy be clarified, then I'll see.
Item number 9.
Number 5. This matter of previous operation petitioner took advantage.
Respondent number 5.
Yes. So see, this is with regard to imposition of penalty for carrying of sand vehicles with overloading. So, my client is a corporation who, as on date,
But possibly this cannot be taken up by this bench.
No, this is the assigned matter.
Assigned before the bench taking up Group 9 matter. Not by name. All right, please come. This matter has been assigned by the Honorable Chief Justice to the bench taking up Group 9 matters. Stop paragraph. Let the same be released from the list of this bench for want of determination and be placed before the bench as per the assignment of the Honorable Chief Justice.
Number 10 and 11.
This matter, your lordship recollects, is towards
Lift.
Yes.
What happened?
Out of 14 matters, 11 is plying.
and 3 more or less 80% concession. And one last chance I beg your lordship. The lift is installed due to my lord's.
Of course, my lord.
Please
we
come.
all-
We are
Everybody.
Down to your lordship.
No, you all also.
Though corporation doesn't have any interest, we have given all no objection, and it's for the benefit of the old and the sick in the premises.
Learned advocate representing, you are representing? Subroto Gupta, representing Subroto Gupta.
Subroto Gupta is the petitioner and Manoju Gupta is the respondent.
In one of the writ petition, he is the
Yes,
petitioner.
yes.
The other one, he is
Subroto
the
Gupta.
Subroto Gupta and others. Submits upon instruction that out of 14 lifts to be installed, 11 are already functioning. Stop. It has been submitted that the rest 3 will be made operational soon. But shortly likhe din. ঠিক আছে? Prayer has been made to adjourn the matter for one more occasion. Stop. Next. How long will it take?
March. By this time, everything will be completed.
It can be disposed of. See, there is no requirement of keeping it pending.
Again,
because nobody is facing any problem now.
My lord is the electrical authorities. They have to do that.
No, 11 is functional. That means electricity is given.
Yes.
Now the rest 3 will also be given.
It's up to them. We have got no axe to grind.
No, that I understand. What? Dispose?
No, my lord. Only keep it. Last occasion, I have to report, my lord, that everything is done.
March is too long a time. We are in November. December, January, I'll keep it in February. Released on 3rd February.
আমার কিছু না তোমাদের ব্যাপার কবের মধ্যে করবে all depends
3rd of February I've kept it.
Grateful.
Yes.
Item number 12.
Well, that Durga Puja Mahesthala municipality.
The writ petition
Well,
appears to have served its purpose.
This is the contempt application, my lord.
Writ also will go. Stop. The writ petition appears to have served its purpose. Stop. Accordingly, the writ petition and the connected application both stands disposed of.
The writ petition was disposed of earlier, my lord.
Writ was disposed?
It was disposed of, my lord. We came thereafter.
The writ petition and the writ petition stood disposed of. Stop. The contempt application has served its purpose. Stop. The same stands disposed of.
I'm so grateful, my lord.
Next.
Full matter. Item number 13.
None appears on behalf of the second appeal appellant at the time of call. Since the matter is a pretty old one, a further opportunity is granted to the parties to take steps. Stop. Release the same once again on 17th November. Stop. It is made clear that in the event the parties are not represented, ex parte order will be passed. Next. Same order will go down. He'll call one by one.
Number 14.
Same.
15.
Same.
16.
Just call on.
17. 18. 19. 20. 21. 22. 23. 24. 25. 26. 27. 28. 29. 30. 31. 32. 33. 34. 35 36. 37. 38. 37.
38. Yes. What is the matter? Who is your other side?
Yesterday, I don't know. Yesterday means for time, not today.
Yesterday it was sought.
But yesterday.
Very well, not today. Next.
$39.
39, is anybody appearing? It's a motion matter. Let me see once. Monthly list not today, Chila. None appears on behalf of the petitioner at the time of call. Released on 10th. Tomba 10th.
Regarding 38, my lord. Matter may be taken on Friday, my lord.
Which one?
38. 38.
Who is your other side?
I do not know this other side.
Hey, how do you say it will be taken up on Friday? Let it appear. Same order.
Part-1.
Yesterday was not today, so it's taken up today. Today also nobody is there. Now I'll start dismissing and then the councils will come. All right, Monday. Order, record and order. Yes. Yes.
Yesterday, I also called the learned advocate of the state.
Who is there?
Mujibur Rahman.
Where is he? What is the matter? Place it.
Matter relating to the higher scale of pay matters. I cover by the judgment of the larger bench matter. Before entering into the service matter, I pursue my master degree. I pay for the similar order matter, page 40 matters. Man.
Did you make any representation?
Yes, madam.
Where is it?
It's 30.
Please come. None appears on behalf of the respondents. Affidavit of service taken on record. The petitioner seeks higher scale of pay. Step. It has been submitted that the petitioner will be covered by the decision taken by the court, taken by the special bench. Now, decision na kore judgment of the special bench dated 7th February 2024. In a bunch of writ petitions, one of which is WPA 303 of 2023. Utpal, Kanti, Koron versus State of West Bengal and others. Stop. A representation from the petitioner is pending consideration at the end of the authority. Stop. Without entering into the merit of the said representation, the instant writ petition is disposed of by directing the District Inspector of Schools Secondary Education, South 24 Parganas, to consider and dispose of the petitioner's prayer for grant of higher scale of pay in accordance with law and in line with the judgment passed by the Honorable Special Bench in the matter mentioned herein above at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken by the authority without any further delay. Disposed. Yes. Next.
43.
Lordship, Shami Mulbadi is appearing on behalf of the petitioner, Lordship. He is engaged in courtroom number 11, Lordship. Praying for a Passover, Lordship.
Passover will become very difficult because I'll go to the combined list.
Then, my lord, not today.
Not today.
Much obliged, my
Maran, I appear in the petition.
What is it?
Madam, yesterday your lordships disposed of the several matters
Yes.
to additional incremental benefit. So far, this is the difference. The only, my lord, the petitioner retired in 2022. And thereafter, my lord, the overdrawn amount was deposited. Although in view of the Rofik Mas, it was not to be deposited.
Overdrawn amount was refunded.
Refunded.
Overdrawn means the 3% which you got.
Yes.
That was refunded.
That was it. This is the only difference.
All right.
But my lord, when the twofold submission I shall be making, that the refund was made prior to the retirement of 6 months. Prior to retirement of 6 months, that overdrawn was made.
And
that
the
is also
refund is from 2017 onwards.
2017 onwards. That is there.
2017,
Yes,
are you sure?
I was receiving, I was enjoying.
Yes, prior to
I was
2017.
enjoying. Everything was given. But at the time of retirement, your lordship knows that on the basis of the hardships, when he was compelled to deposit that amount. So I retired, whereas I have deposited that amount. Pay fixation was also made. Your lordships kindly have a look, page 23. That was given in 2016.
Yesterday's order has been put up in the server.
It has not been uploaded.
Not been uploaded.
Not been uploaded. এখন দেখে নাও, এখন দিয়েছে কিনা?
Because চলে গেছে. It has been sent. Maybe it will be put up in the server.
Your lordships kindly have a look, page 23.
Yes, from 92 you can
2016, this was given. Everything was given. After 2017, this memo, next page, page 24. Well, I was compelled to deposit the said prior to 6 months of my retirement, page 25.
But then, when did the school get upgraded?
The school upgraded, page 21, in the year of 2015. Right?
So, your imparting higher education is from 2015.
Yes.
The period is from 2015 to 17.
No, last, up to the date of retirement, I was allowed to enjoy in terms of the pay fixation made by the authority, page 23.
This is after taking into consideration your upgraded pay or not?
Upgraded period, certainly. Otherwise, how could I email this? This benefit was given.
What is your prayer today? Is it for the fund of
prayer
the
B, prayer
overdrawn amount or not?
Yes, prayer B, if your lordships kindly have a look. To revise the pension payment order upon taking into consideration 3% additional increment benefit and to refund the alleged overdrawn amount of such and such along with the interest per annum without any hindrance from it.
What is your submission, madam? No objection means? Prayer is being considered. What will be your submission with regard to the refund of the overdrawn amount? What will be your submission with regard to pay fixation? Why did you not take it? September it was served? When was it served? October. Then?
22nd September it was served. It was received by the office of the GP office.
Yes, immediately prior to the vacation it was
Prior
served.
to the vacation. Let the abbreviated service be kept.
Have you checked up the law with regard to refund of overdrawn amount? What?
My lord, generally it is being given as per the orders that have been passed by my
Not my lord, as per the Supreme Court's order. Right? Overdrawn amount is required to be refunded and there are certain parameters when to refund it. Does the petitioner fulfill those parameters?
then I have to like get taking 10%.
Please come. The petitioner is a retired school teacher. Stuff. He received 3% additional increment for imparting higher secondary education in terms of the government memorandum notification dated, what is the date? 2010 notification date?
No, 2010 টা বলছি
January
2010 এর নোটিফিকেশন ডেটটা দেখো কালকে যেটা বলি 10 February
10th February 2010. Stop. The payment of the petitioner was fixed accordingly. Stop. 6 months prior to his retirement, the petitioner was directed to refund the amount overdrawn by him in view of the withdrawal of the 2010 notification by the state government by a subsequent notification dated 2017 notification date?
Page 22nd March 2017.
22nd March 2017. ঠিক আছে? Apprehending that he will not get his terminal dues in proper time, the petitioner refunded the amount which was found to be overdrawn by him after 2017. Stop. The issue of withdrawal of the notification of the year 2010 was challenged before the court. And
the notification of 2017 was challenged.
কি বললাম?
Not 2010, 2017.
Year 2017 was challenged before the court and the Honorable Division Bench in, give me the case numbers.
It is a picture.
Justice Chakraborty's order. Yesterday you placed.
No, single bench order.
Division Bench's order.
Justice Tendon's order.
No, then Justice Chakraborty's order is also there, isn't it?
No. Justice Tendon's order. Justice Chakraborty's order was quoted possibly. Justice Tendon's order was.
আচ্ছা কি বললাম?
Last portions, my lord, the
Division Bench on 7th January 2025 in FMA ETA in the matter of such and such. Was pleased to set aside and quash the impugned memo dated 22nd March 2017.
আমি যে নিয়ে গেছিলাম দাগ দিয়ে আছে আমাদের দাগ দিয়াটা দিয়ে দিলাম
The Honorable Division Bench was pleased to hold that the candidates would be entitled to the grant of 3% additional increment in terms of ROPA 2009 with effect from the date of appointment as headmaster or from the date of upgradation of the school. Stop. Paragraph. On setting aside of the impugned memo by which the petitioner was found to be drawing excess amount, the right of the petitioner to receive 3% additional interest.
Increment.
Additional increment. Additional increment revives. Stop. The as the petitioner has already refunded the same immediately prior to his retirement. Accordingly, the amount refunded by the petitioner is required to be returned to him. Stop. Paragraph. The instant writ petition stands disposed of by directing the District Inspector of Schools, South Secondary Education, South 24 Parganas, to recalculate the scale of pay of the petitioner.
I interrupt. Page 23, your lordship standing. Refixation was already made. If they proceed in terms of the refixation, it will be sufficient. Your lordship standing, page 23.
Yes, this
Top portions. With reference to the above subject, I'm saying.
So this refixation is all right.
Yes, that is all right.
আচ্ছা ঠিক আছে তাহলে লিখুন তো
In terms of this.
না টু হ্যাঁ
21st January
ঠিক আছে হ্যাঁ ওটা বাদ দিয়ে দিন ডাইরেক্টিং দি ডিআই to act in terms of the refixation of pay of the petitioner as made on 21st January 2016 and disburse the arrears of the petitioner in terms of the said refixation. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. All payment shall be made. All payment shall be made positively within a period of 4 months from the date of refixation. Stop. যেখানে 8 weeks টা বললাম উপরে 8 weeks বললাম না ওইখানে লিখবেন revised PPO shall be issued. By the DPPG is a party?
Yes.
By the DPPG. হ্যাঁ ওইখানে
Report number 6.
ঠিক আছে তারপরে all payment to be made within a period of 4 months refixation.
Only one line, although it is applied, including the overdrawn. The lordship can be.
Obviously, I have mentioned that overdrawn amount has to be refunded.
It is mentioned. Then extremely grateful.
I appeal to the petitioner. A similar prayer, my lord, a similar matter, the grant of 3% additional increment, my lord. The petitioner is an in-service teacher, my lord, and the entitlement, my lord, is from 28th of July 2016. His entitlement, my lord, for that.
From 2016, you are not getting?
From 2016, my lord.
When was the upgradation made and when were you serving in the upgraded post?
I was serving upgraded, my lord.
And you are working since?
May I just place, my lord? I joined this school, my lord, in the year 2016, my lord.
2016.
Your lordship, there's a representation, my lord.
All right, please come. The petitioner prays for consideration of his representation, seeking 3% additional increment and refixation of his pay in terms of the notification. Where is your representation?
At page 15, my lord.
15. Are the notification numbers mentioned?
Yes, my notification numbers are mentioned, my lord.
2010 এ একটা বললাম না এর আগেরটাতে বললাম দেখুন 10th of February 2010
order annexed to this petition at page 30. That similar order may suffice the cause of the petitioner, my lord.
Page 13?
Page 30, my lord.
39. 30.
It was an order of the cabinet means, my lord, the similar matter, my lord.
কি বললাম Dated 10th February 2010. Stop. Next. A representation by the petitioner is pending consideration. Stop. The petitioner relies upon the order passed by the honorable division bench in the matter of আগের ম্যাটারে যে ডিভিশন বেঞ্চের অর্ডারটা দিলাম জাস্টিস হরিশ ট্যান্ডনের ওইটাই দিয়ে দেবেন অর্ডারের ডেট অ্যান্ড দি কেস নাম্বার ঠিক আছে in support of the submission that he would be entitled to the 3% additional increment ঠিক আছে without entering into the merit of the claim of the petitioner at this stage, the instant writ petition is disposed of by directing the District Inspector of Schools, Secondary Education, Purva Mendipur, to take a decision on the prayer of the petitioner strictly in accordance with law and in line with the law laid down by the court at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The additional payment, no, the additional increment, if found admissible in case of the petitioner, shall be disbursed without any further delay. Disposed.
I'm grateful.
Yes.
But this is my prayer for compassionate appointment, my lord, where my lord the husband, my lord, died in 2021, my lord June, and my lord I made this application my lord, in 2022 for compassionate appointment. My lord,
you are the?
I'm the wife.
Wife.
So, my lord, there was a problem in this. My lord, what happened here? My lord, I passed my lord from an Odia medium school. So, my lord, what happened? My lord, I was orally informed that my prayer was forwarded to the commission for the purpose of compassionate appointment by the district inspector of schools. But after that, man, I was verbally intimated that there was no vacancy in Odia media. So this is why I could not be given with this. So man, I reapplied again in the Bengali medium schools as well because I do have.
Do you have the qualification
I
to
do.
teach Bengali?
Yes. So I do have that. So accordingly, as per their instruction, man, I have applied that. That is pending consideration. I pray before your lordship to be considered that one.
But then, as per their instruction, the second application was made when?
In 2024, as per their instruction.
Where is their instruction?
That is not there. Even my rejection is not there. They even did not reject me that by saying this. This is only the oral rejection or oral intimation that I will not be given because it was ODR. So I just only request your lordship to see page number 12 once. 12, my lord, is the district inspector forwarding my case to the commission, Regional School Service Commission, Western Region. So my lordship will see it is back in 2022. Thereafter, my lord, nothing happened. My lord kindly then turns over, my lord kindly sees once my representation at next page. There, my lord, I say that after my the husband was teacher in such and such, third paragraph, fourth, my lord. That thereafter I applied. Has your lordship got this one? Applied before DI on 24th. Oh, I'm sorry. Third paragraph, after demise of my husband, applied for district inspector Paschim Medinipur. But as I was a student in Odisha board, I was not observed in the job as there was no vacancy in the Odia school at that time. That thereafter I applied before DI on 19th of April 20.
Oh, let me hear once.
Yes.
Not received the brief also.
No, what appears for us? The husband died earlier before he made the first application in 2022.
Yes.
So before that, the husband died. Now the second application, whether it is time but or not, that is also.
All right, first application, what is the fate?
Yes.
He is not challenging that one. This is his submission.
No, he says that is pending.
He has made a subsequent application.
Maybe that does not mean that she has foregone. She needs compassionate appointment.
But it's not punishment that a person can make as many applications as he wishes.
You continue with the first one. You take that to its logical conclusion. Are you aware how many Odia medium schools are there in the state? No.
But he has applied to put his case has been transferred to or recommended to
Western region.
But I have to take instruction whether there is any vacancy or not, and what was.
And if there is no vacancy, then where the petitioner can be accommodated?
Yes.
Provided the petitioner knows the other language.
Correct, yes.
Please come. The petitioner seeks compassionate appointment. Stop. Her husband died in harness on 17th June 2021, and she applied for the job in the year 2022.
Yes.
Stop. The petitioner preferred an Odia medium school to be appointed in the Group C post. Stop. On being orally informed that there is no vacancy in the Odia medium school. Acha. She made further application on 19th April 2024 for being appointed in a Bengali medium school. Stop. The earlier application of the petitioner was forwarded by the DI of Schools, Secondary Education Paschim Mednipur to the West Bengal Regional School Service Commission, Western Region, on 6th December 2022. Stop. There is no response from the end of the commission with regard to the fate of her application.
Fine.
Stop. Next. The subsequent application made by the petitioner is also undecided. Stop. None represents the state respondents. Stop. Your service?
Yes, yes, madam.
Service is taken on record. Learned advocate representing the commission and the state shall come ready with proper instruction with regard to the fate of the petitioner's initial application of the year 2022 and the subsequent application under section in the year 2024. Released 18th November, 2 weeks.
Grateful. Right.
Acha, let a further notice be served
Yes.
upon the non-appearing respondent. Check up from the GP's office who is appearing.
I'll do that.
And please serve.
Grateful.
My lord, I am for the petitioner, my lord. I am led by Mr. Sandip Kumar De, my lord. My lord, is currently code number 39, my lord. Kindly.
What is your name?
My name is Ovikun.
Where is Obijit Sarkar?
My lord, he is an advocate on record.
Where is he?
My lord, he is at home, my lord. He is
At home? The matter is being called on.
he suffering from the spinal problem, my lord.
He can join online also.
My lord, he not in a position to.
Not in a position.
My lord,
What is to be? What are you praying?
Only, my lord, not today, my lord.
Not today. What is the matter? Yesterday also it was adjourned. Now I'll stop adjourning matters and start dismissing.
No, my lord.
What is the matter? For increment. This is pending. 23rd of June. Call your senior. I'm passing it over. No adjournment. Call him. Please wait. Yes. 49.
For the petitioner, this is relating to compassionate appointment. Let's kindly come to the rejection order, page 33. A type copy as page 34.
Family income criteria you fail to satisfy.
Yes. This is totally wrong.
Wrong. Calculation is wrong.
Yes. they have shows two income. That is one is, my lord, 23,750. That is
Tell me one thing. The rejection is of 22, August 22. You
that
filed
was
the writ
served only
petition.
after the filing of the writ petition. Kindly see the last order passed by the Supreme Court. I filed a writ petition. When they are informed that that has been rejected, they served after this. That is 30th June 2000.
All right. What is your submission that the...
They calculated, kindly see, at 23,750.
Yes.
See, that is my now present pension. Kindly come to page 26. Kindly come to page 26. B, middle portion B, 23,750. That this is my present pension. That was with up to 30th April 2026. That this added as others income.
Your family income is 36,000. 60% of the family pension is such and such, and other income is...
From where he got it, I don't. But that is the...
yes. Where is the state?
The state I have served. Mr. Bhaskar Prasad Bois.
Call him. Call him. I'm passing it over.
I am for the petition.
Yes.
It's interest on gratuity. Legal heirs has come before your lordship.
Who has come?
Legal heirs, lordship.
Legal heir? Who is the legal heir?
Kindly come page 11, lordship, the PPO, a wife, son and daughter.
What do you want?
Interest on gratuity, lordship, and area pension.
2nd January 2025 is the PPO. Person retired on?
Died in harness, lordship.
Oh, died in harness. 11 January 23. PPO died in harness. Interest on gratuity 5%.
Lordship, I am covered by your lordship order. This 7%. Lordship.
When? 2 years back. Which year? Which year order?
Lordship, 2024, lordship. Lordship, kindly see.
No.
Lordship, kindly
Now the
see.
interest rate has
Lordship,
gone down.
kindly, lordship.
Nothing doing. Died in harness. 5% interest on gratuity.
And kindly 6%, lordship, kindly.
No, don't bargain. Next.
I am for the petition, lordship. Interest on gratuity on single people.
Gratuity only. This is in 2016 is the PPO. You have come after 10 years. Dismiss. Nothing doing, dismissed. On the ground of delay.
I am for the petition, lordship. Interest on gratuity.
Yes.
The widow has come before your lordship.
Widow has come.
Lordship.
Dismissed. Next.
I am for the petition, lordship. This interest on gratuity and area pension. This is also legal heirs has come before your lordship. Wife and son.
Yes. Gratuity only?
Gratuity and area pension.
All right, gratuity area pension. Yes.
But I appear for the writ petitioner, my lord. My lord, in this case, my lord, the petitioner, my lord, had appeared no. 54, your lordship. Yes. My lord, the petitioner participated. The school service commission, my lord.
Served?
Yes.
The
Affidavit of service.
Do you appear? No.
I appear, but this matter is not served upon me.
তোকে দিইনি আমি না কমিশনে পাঠিয়েছি he says my lord commission has not engaged him Dr. Patro
এটা not a very manner but not good brief
হ্যাঁ উনি আপনি আপনি জানেন এটা কমিশনের হয়ে স্কুল সার্ভিস কমিশন আপনি জানেন স্টেটের হয়ে
State, you must have served the GP's office. Somebody has been engaged from there. Board of Secondary Education is also there.
If it is the second SLST matter, then Mr. Nag is sitting outside. He normally appears in the second SLST.
Check up with Mr. Nag.
But may I state the facts, my lord?
No, in the absence of the other side, it will not be proper. Ensure presence of your learned friend so that the matter can be taken up and disposed of or any effective order passed.
Yes, my lord. But my lord, I am in hot haste, my lord, for the simple reason, my lord, the commission is going to complete the
Board
selection.
Secondary Education.
Yes, and the secondary education is also, but the commission is, my lord, the answering respondent, Mr. Nag, my learned friend, my lord, his client has been served.
Is it a second SLST matter?
Yeah, they say 2016, my lord, and my lord, they say I am, my lord, seeking certain advantage, my lord, which is derived from the new rule. Now, my lord, may I state the facts in a nutshell?
No.
Give us a copy, my lord.
Copy has
Already been served.
Check up.
Soft copy will do.
Oh, I will serve.
For a
No.
hard copy.
I understand, but then copy must have been served because this is his submission. Check
Yes,
up.
it is.
Service has been done.
What happened is must have been served in the receiving section. By the time it comes to expedite the matter, my lord, let a soft copy be
Then
given.
please ensure the presence of the.
But it is not possible so far the board is concerned, my lord. Mr. Nag is, my lord, extremely generous. My lord, he will, my lord, be here.
He'll be there for the commission.
He is
right?
there. He runs the commission now.
State is also required,
Huh?
and at the same time the board.
Board, my lord, kindly excuse me, my lord. My lord, board, my lord,
Serve Miss Bhattacharya. She can come.
I can send a soft copy, my lord, every time.
Please do.
Yes.
Give an intimation at least.
Friday, my lord, your lordship will be.
Tomorrow is a holiday. If you want it on Friday, it will be on Friday. I
no.
keep it on Friday. Please come.
নামগুলো কল্লোল বোস
None appears on behalf of the respondents. Stop. Let notice be served upon the respondents intimating that the matter will appear in the list on 7th. Service is taken on record. Please check everybody. You know who appears for whom? Inquire.
Unless,
on
my lord,
soft
my lord,
copy.
I tell your lordship, my lord, Mrs. Bhattacharya, my lord, in Bar Station, she sits in Bar Station 5. I can, my lord, send a soft copy.
Your lordship,
but kindly, my lord, record an order directing me that I can serve her, my lord, so that
your lordship, Mrs. Bhattacharya appears for the board. She will not be here on 7th. She will be in Supreme Court.
Baba.
She may be in the Court of Justice, also International Court of Justice. The court doesn't have any objection, but somebody should be here. Thursday will be
May I make one humble submission?
Thursday. I'll keep it on Thursday.
Thursday, my lord, day after tomorrow.
Day after tomorrow.
Yes.
All right.
Yes,
at the top, my lord, at the top. But at the top. At the top, my lord.
Yes, it's there at the top. It will be taken up.
54 we have reached, right?
Yes. Old matters were there. It will be taken up. Don't worry. Next.
But I tell your lordship, the presence of the West Bengal Board of Secondary Education, my lord, is not very important.
Doesn't matter.
Yes.
Even then, other factors are also there.
Right.
So.
No, I understand.
55.
Lordship, I'm appearing for the petitioner on behalf of Mr. Shomik Ganguly. He could not attend the court as his father has expired on last week, so he has to perform his last rituals. On this basis, I pray at least 15 days adjournment in this matter.
Learned advocate for the petitioner has suffered a bereavement. Stop. Prayer for adjournment has been made. Stop. Released on 24th November. Passover কটা আছে? একটা দুটো আছে। ডাকুন এক।
Passover matter, item number 48.
Petitioner not yet here. Get hold of your learned friend. Next.
Item number 49.
I'll make it not today, my lords.
49 not today.
49.
49 your other side is here.
Yes, my learned friend to the commissioner Bhaskopasad Boishwar for the state, but he told that he will come at 1 p.m.
1 p.m. all right, ঠিক আছে। শো একটা ওঠার আগে ডাকবেন।
Well, 48 kindly make it not today, my lord.
Hi. It can be disposed of. Again, next day it will remain pending. I'll dispose it off. Don't worry.
My lord,
You come at 1:15. Another Passover matter is there. I'll take it up. Oh, there he's come. He's come already.
He's extremely sorry. 48 minutes.
Keep your juniors prepared so that the court is not held up.
I'm sorry. Extremely sorry. I was the other building I was.
Yes.
The affidavit of service. Matter is very short. My client retired on 31st May 2020.
There is a representation.
Yes, there is a representation. He is asking for one increment benefit because government gives 1 month's relaxation. The time relaxation for that increment. Why I'm telling so? 1st of January to 31st of July, this period is taken into account for increment. In between this period, if somebody crosses 6 months more, 6 months or more, he is given the benefit. Now,
So where is your representation?
Yes, representations are there. Annexures P7, 8, 9, and 10.
No, which one would you like to be considered?
Anyone will, all of the same.
Oh, it is to be considered by the district inspector of schools.
Yes.
Where is your representation to the DI? 65. Please.
68, 60.
The petitioner's prayer seeking notional increment benefit is pending consideration. Stop. Without entering into the merit of the same, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Kolkata, North 24 Parganas, to consider and dispose of the said representation in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, the necessary consequential steps for releasing the additional financial benefit shall be taken immediately thereafter. Disposed.
Only one submission, my lord. At the time of considering if some material is presented by my client, that may be taken care of.
Why? Everything is on record.
No, my lord.
How many months and everything are there?
Yes, that is there. My lord.
Then?
But the orders, any order or any other material, tribunal's order or something.
Tribunal's order?
Yeah, state administrator has passed certain orders, that is why.
And at order লিখুন তো ওর সাথে অ্যাড আপ করে দিন learned advocate for the petitioner is directed to forward a copy of the subject representation along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court.
Might. Deep.
Yes.
Item 55.
But I'm for the commission.
Yes, please.
আমরা বোর্ড থেকে আমরা রেসপন্ডেন্ট আমরা বোর্ড থেকে ভ্যাকেন্সি চেয়েছি এখন বোর্ড থেকে
65 combined list. Nobody is there?
এটা কি ম্যাটারটা কি
কম্প্যাশনেট
compassion?
You are for the respondents?
Yes, for the school service commission.
School Service Commission, what is the prayer? To give effect to memo 6th May 38. None appears on behalf of the petitioner at the time of call. No accommodation sought. Dismissed. Next. The 1700 and 2000 matters in the list, you cannot keep them pending if the parties are not interested. Yes.
66, 66, I am for the petitioner. My lord, the petitioners seeking higher scale of pay. My lord, after joining, he is honors teacher. After joining, he took permission from the managing committee. Managing committee by director resolution granted permission and forwarded to the DI for permission, but DI did not respond. This is the covered by the Adiluzzaman Rahman.
Where is the
and also my lord, covered by the special bench judgment. My lord, the matter is pending before the DI.
Forwarding?
Forwarding for higher scale of pay. My lord, page 39, petitioner's representation, page 40, school forwarding letter.
Ashunto? No instruction?
No.
As usual, the petitioner's prayer for higher scale of pay on account of enhancement of his educational qualification is pending consideration before the District Inspector of Schools, Secondary Education, Howrah. Stop. The petitioner relies on the judgment passed by the Honorable Special Bench of this court on 7th February 2024 in the matter of Utpal Kanti Koron and others versus the State of West Bengal and others.
And will be reported in 2024 SCC Online 224.
2024 SCC Online
1274.
1274?
1274.
Reported in such and such. ঠিক আছে? Without entering into the merit of the claim of the petitioner, the instant writ petition stands disposed of by directing the DI of Schools, Secondary Education, Howrah, to consider and dispose of the prayer of the petitioner strictly in accordance with law and in line with the judgment referred to herein above, at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Stop. If the claim of the petitioner is allowed, the necessary consequential steps shall be taken by the authority without any further delay. Disposed.
My lord, the only add online, my lord, petitioner may be allowed to rely, my lord, the judgment, other judgment and Supreme Court judgment before at the time of hearing.
You want a hearing? It will not be within 8 weeks. Then time has to be increased.
No, hearing is...
I have mentioned in line with the order passed by the special...
Hearing is necessary. Otherwise, my lord, all supporting documents for permission was sought for. DI did not respond. That is the special bench and my lord, division bench settled that the permission deemed to have been sanctioned. My lord, the...
যেখানে 8 সপ্তাহ বলেছিলাম সেটা 12 সপ্তাহ করে দেবেন। An opportunity of hearing shall be provided to the petitioner prior to passing the final order. Stop. The petitioner shall be permitted to rely upon all documents in support of his claim at the time of hearing,
including the judgments. Whatever.
All documents.
No, documents, my lord, the... Very good.
Seven, my lord, I am for the petitioner, my lord. My lord, this is my active service, my lord. My lord, in this matter, petition is praying for grant of house rent allowances, which is unpaid from March 2020, my lord.
2020?
My lord.
5 years without the house rent, why?
My lord, what has happened is, my lord...
Your husband, you are the...
My lord, my husband is working in a private organization, my lord.
All right. Show me. Did you ever get house rent?
My lord, I am working from 2013, my lord. I was appointed in the year 2013, my lord. From 2020, my lord, my house rent allowances has been stopped, my lord. I was briefly paid.
Where is the stoppage? Any order was passed?
No, my lord, no order was passed, my lord. My lord, it was reflected in my salary slip, my lord.
Show me, please. Regarding the stoppage, there is nothing mentioned.
No, my lord. My lord, kindly comes to page number 102, my lord.
102?
102.
Yes.
My lord, I was getting house rent allowance of...
5,928.
My lord. That is on February, my lord. My lord,
February
on the next
2020.
page, March 2020, my lord. I haven't been getting any house rent allowance, my lord.
Page 104, I see one salary statement.
Yes, ma'am.
And the HRA is mentioned as 1999?
That is from, my lord, for a brief period of time in 2023 and 2024, I was getting half of my what I used to get, my lord.
Why?
Only 2,000, my lord.
Did you?
I made a representation before.
Where is it?
My lord, in 2020, I had made a representation, my lord. Recently, my lord, I had made a representation on page number 119, my lord. And 108, my lord, in the year 2020, I also made a representation, my lord. My lord,
100 and where is the representation?
108, my lord. That is in the year 2020, my lord.
Thereafter, you did not?
No, my lord.
Why?
My lord, the recent representation I made in 2025, my lord. It's page number 119, 119. My lord, there is an order of the coordinate bench. My lord,
But there is an appeal also preferred.
My lord, there has been no stay on the appeal. The appeal has not been pursued also, my lord.
Yes.
The last order was in 2023, my lord.
But
My
you
lord, there is
disclose that since your husband is working in a private.
Yes, my lord. Yes, my lord. Every year, my lord, we have to file, my lord, a declaration, my lord. I have filed the declaration, my lord.
What?
Disclosing that that my husband is working in a private organization, my lord.
No, the stoppage at the time of stoppage, was any intimation communication made to you? The reason?
No, my lord. There was no intimation mentioned to me, my lord. My lord,
Please come.
My lord, there are similar orders of the honorable coordinate bench, my lord. My lord, I've annexed those orders, my lord. My lord, if lordship kindly comes to my lord, page number
is aggrieved by the stoppage of house rent allowance without any notice. Stop. It has been submitted that the petitioner was receiving house rent allowance of rupees 5928 per month in the year 2020. Stop. The same was abruptly stopped on and from March 2020 till June 2023. Stop. However, for a brief period,
from July 2023 to June 2025.
From July 2023 till June 2025, house rent at a reduced rate amounting to rupees 1,999 was paid to her. Stop. No reason whatsoever has been disclosed for stoppage of the house rent. Stop. The petitioner assumes that as our husband is working in a private organization, the authority may have stopped the house rent allowance, which she is entitled to in accordance with law. Stop. Next. The a coordinate bench of this court on 21st May 2024.
My lord, page number 116, 2025.
The bench of this court on 24th April 2025 in 6926 of 2025. Kanta Bandyopadhyay versus the state of West Bengal and others was pleased to direct the authority to release house rent allowance, both current and arrear, in favor of the petitioner, along with interest at the rate of 6% per annum from the date on which the same became payable till the date of actual payment. Stop. The till date, there is no stay of operation of the aforesaid decision passed by the court. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the District Inspector of Schools. Which place?
My lord.
Secondary Education, North 24 Parganas. To take steps for releasing the house rent allowance of the petitioner, which she was receiving along with the arrears. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The petitioner shall be paid interest at the rate of 6% per annum on the arrears from the date it fell due till the date of actual payment.
My lord, the current HRA payment should also.
Yes, yes. The current house rent allowance shall be paid promptly on the due date. This post.
My lord, the affidavit service.
Yes, service is taken on record. Okay. Dismiss for default.
9. 9, my lord, I am appearing for the petition. Service be kept on record, my lord. Matter is relating to transfer on special ground, my lord, of the child of the petitioner, my lord. My lord, kindly come to page 44, the disability certificate, my lord. 70%.
Where is your application?
My lord, application made in the form of, not in the form of prescribed form, my lord, but in the form of representation.
Any prescribed form on special ground, kindly come to the.
My lord, kindly, I am relying the judgment passed by the Honorable Division.
My lord, no objection has been given.
Don't give the soft copy, you give the date and number, it will be put up on the screen.
My lord, on special ground, my lord, no prescribed form is required. Kindly come to the school, my lord.
This is
page, my lord, 58, my lord.
Yes.
The teacher shall submit, my lord.
Which portion? 58 is a big page. 7. Yes.
Procedure for general transfer on special grounds, my lord.
Yes.
The teacher shall submit application with sufficient documents for consideration of the managing committee in connection with the transfer on medical ground, my lord. And my lord, the managing committee may, after the examination of the prayer and after receiving views of
no, that is thereafter. You are at the application stage.
Yes, my application has been made, my lord. No objection has been given, my lord, by the school, my lord, and forwarded to the district inspector of school, my lord. Kindly come to page, my lord. 65, my lord. For a moment, my lord.
Yes, 65.
65, my lord. The school has sent to the district inspector of school, my lord. No objection, with no objection, my lord, page 66, my lord. And name of the school, my lord, which is still now vacant, my lord, that has mentioned in my application, my lord.
Yes. Please come. The petitioner seeks
application page 40
transfer on special ground.
I only want to submit one thing, my lord. Now, my lord, it is the duty of the DI.
Was forwarded by the school to the District Inspector of Schools, Secondary Education, Howrah. Stop. Thereafter, there has been no response from the end of the DI. Stop. What is your submission?
Malad, in case of medical transfer on medical ground, Malad, when the transfer application was forwarded by the school authority to the DI, it is the duty of the district inspector of school to obtain a medical report from the COMH of the concerned district. And if the COMH report suggests for transfer, then only district inspector of school shall forward the transfer application.
Why did you make the submission that it was not made in the proper form?
Malad, it is not in proper form.
No, Malad, there is not required, Malad, for proper form,
It is not in proper form, Malad. I have also relied on judgment, and I have also already, Malad, provided the number.
None appears on behalf of the state respondents. Stop. The as per the rules for transfer, procedure for transfer, general transfer on special ground, a teacher is required to submit application with sufficient documents for consideration of the managing committee in connection with the transfer on medical ground. Stop. The managing committee, after examination of the prayer and after receiving the views of the medical practitioner of the committee, is required to forward the prayer with the resolution to the district inspector of schools. Stop. The district inspector of schools, now, aage bolam to DI of schools, stop ta tule din, who is required to forward the application after verification of the vacancy as per option submitted by the employee, where he/she desires to be transferred to the school education department.
No.
Stop. The district inspector of schools appears to have received the
Malad, rules has been amended, Malad, in 2021. Malad, 8th September 2021, transfer rule has been amended. And now, Malad, the School Service Commission is the ultimate authority who shall issue recommendation for transfer.
Has received the application from the, not application, the documents in relation to the application for transfer made by the petitioner in July 2025. Stop. There is no response from the end of the district inspector of schools. Stop. The instant writ petition accordingly stands disposed of by directing the district inspector of schools to take prompt necessary steps upon consideration of the documents forwarded by the school authority in accordance with law. Stop. The necessary consequential steps by the district inspector of schools shall be taken at the earliest, but positively within a period of 4 weeks from the date of communication of this order.
And my lord, kindly, my lord, one line be added, my lord. If district inspector of school forwarded the same to the Central School Service Commission, my lord, they will take steps accordingly, my lord. Kindly.
It has been mentioned all consequential steps. It will cover.
My lord.
Next, 70. 70. Yes.
Lordship, that has led us to overdrawn of amount 1,43,925, Lordship. Finally come, Lordship, page 16 and 17, Lordship. 16 is the memo and 17 is the tier form.
(2008).
Yes, Lordship.
And you are coming after so many days. Who has come?
Lordship, petitioner itself.
Petitioner himself has come?
Yes, Lordship.
What was he doing for so many years?
Lordship, I have to take instruction why the delay has been given.
What have you mentioned about the delay?
Lordship, the pension payment order issued on 2012.
2012?
Yes.
I can see the PPO of 2009.
No, Lordship, revised PPO is...
Revision is later on. Initial PPO is 2009.
2009.
Then, what were you doing for so many days? Please come. The petitioner seeks refund of an overdraw amount.
Yes, Lordship.
Which he refunded while he was in service in the year 2008. Stuff. From the documents annexed to the writ petition, it appears that the petitioner retired from service in November 2008. Stuff. Pension payment order was issued in his favor in January 2009. Stuff. The petitioner has approached this court seeking refund of the amount paid by him in September 2025. Stop. There is no representation from the end of the petitioner before the authority seeking refund of the amount paid. Stop. There is neither any explanation in the writ petition explaining the delay in approaching the court. Stop. The court is not convinced with the stand taken by the petitioner in approaching the court at such a delayed point of time. Stop. The writ petition fails and is hereby dismissed. Service is taken on record. Next.
71.
I'm for the respond.
Record appearance dismissed for default. Yes. Yes.
That is He has come before your lordship.
Has Wakalat number been filed? All right. Secondary board. Yes.
That challenging the order passed by the board, that if your lordship kindly turns to the impugned order once. But the impugned order starts from page 15. Kindly turns to, this is the hearing order which has been passed after the order of this honorable court was passed. Kindly
yes.
Page 15. The Utsav Mukhar Sarkar, the private respondent, was appointed so and so, but I am not going to it. Then your lordship kindly turns to his absence regularized. Fifth point from top. Well, got it? His absence regularized under medical leave, half pay leave, earned leave, leave without pay from Swanso to Swanso, referred to the West Bengal Board of Secondary Education for approval. Medical leave with pay from Swanso from Swanso and Swanso 42 days. Half average pay.
It's all right. Then what?
Then, on 17th of April 2015, the board asked the headmaster to meet the concerned officer regarding the leave regularization. Then, on 8th of March 2018, in response to the school letter dated Swanso, approved the period from 21st of October 2011 to 1st of June 2014 as leave without pay. Then, copies were sent to the Commissioner of Schools, Swanso, and the teacher concerned. The President heard the private respondent and the headmaster on 18th August 2025 and then passed the order. Kindly says, B. The memo number Swanso issued by the board approving the sanction of EOL without pay in favor of Utsav Mukhar Sarkar stands rescinded after revisiting the order of the Honorable Court dated 2014 in WBCRC of Swanso. The period from 21st of October 2011 to 1st of June 2014, which the private respondent was on leave, should be treated as spent on duty and therefore it would be leave with pay. But at the earlier, it was the
leave without
pay by the board.
Now it has
how it can be? Kindly, but the interesting part I am coming later on. The health condition of the private respondents is to be assessed by the Chief Medical Officer of Health, Paschim Bardhaman, preferably within 6 weeks, and the report to be submitted to the board endorsing copies of the DI and the school authority. Then, if your lordship kindly turns to page 21. the board is writing to the headmaster of the school. With reference to the above mentioned subject, I am directed to inform you that the absence from duty 2011 to 2014 in favor of the private respondent has been approved as leave without pay as per leave rules. Now, the board is taking absolutely a U-turn. This was in 2018 to the headmaster. Then, your lordship, kindly comes to the High Court order. What the High Court has actually said. High Court has never said to regularize the leave.
1 minute. From 11 to 14, the petitioner did not go to the school.
No,
he did
no,
not
From
attend
9
school.
to 14.
All right. 20.
But I will be placing some interesting facts. Kindly turns to page 29. What the petitioner has, what the private respondent has approached the application of the private respondents to the headmaster, page 29. Leave for regularization of leave from the period of 2009 to 2014. Kindly cease. With respect, with due respect, I beg to inform you that so-and-so, I joined my post on 2nd June 2014 with the order of the Honorable High Court. During that long period of enjoyed 42 days of medical leave, 60 days of half pay leave, then so-and-so, and 1727 days of leave without pay. He is saying that I enjoyed without pay. Then, therefore, pray and hope that you would be kind enough to grant my aforesaid prayer as early as possible. But if the incumbent is asking for leave without pay, how the board can ask for leave with pay? Kindly see the order of the board. Page 16.
Show me the order which was considered by the authority to arrive at such a conclusion.
Yes. Kindly turns to the High Court's order, page 22.
Yes.
It was in 2012. The petitioner was appointed so-and-so of the school on recommendation of the appointment was subsequently approved by the not reading that. Thereafter, according to the petitioner, because of his ill health and was hospitalized on June 30th, 2009, and after recovery therefrom joined the school on 5th October 2009. Subsequently, he fell ill again and was under the treatment of the medical practitioner. The petitioner says that he has submitted the medical certificate in support of his ailment and have also applied for leave. It is alleged that after his recovery, he went to join the school, but the headmaster of the same school did not allow him to join. The learned advocate appearing for the school authority submits that the aforesaid allegation of the petitioner is not correct. He further submits that the petitioner shall be allowed to join provided fitness certificate from a registered medical practitioner is produced. The learned advocate so-and-so, in view of the above, the petitioner shall go to the school on or before so-and-so and shall submit the fitness certificate issued by the registered medical practitioner. The school authority shall allow him to join subject to the regularization of the leave by the appropriate authority. The court has directed the appropriate authority to regularize the leave. Now, what is his application? Page 29. This order was passed in...
1 minute. I'm at page 24.
24, yes. This was in contempt.
The leave has not been approved.
Kindly turn to page 26. The contempt was dismissed. 27.
Contempt dismissed.
Yes, page 27, last paragraph. This court therefore does not find any ground to hold the alleged contemptor, I was the contemptor, liable to be punished under the Contempt of Courts Act. Contempt application is therefore dismissed. Rule issued against the alleged contemptor is hereby discharged.
Yes.
Now, this order was passed in 2014. The parent order was passed in 2012. The board directed me, kindly turns to page 21. In 2018, after 6 years of passing the order, the board said that the leave to be treated as leave without pay. Now, the private respondent has made a prayer, page 29, how his leave is to be calculated. He has mentioned it there.
The board.
No, Lordship. Now, this petitioner was absent from October 2009 till June 2014. Now, Lordship, he made an application to join the school at 2011. School did not allow. Therefore, Lordship, the school
a managing committee resolution of the school was forwarded to the board, regularizing the pay, his leave from 21st October 2009 to October 2011 as leave without pay. And your lordship, the school requested board to decide upon the absence period from 21st October 2011 up to 1st June 2014. Well, this is in question now because that portion the school has already approved as leave without pay, the previous portion. Now this portion. Now what happened when this application was made before board, your lordship, board by letter an order passed in 2018, that is at page 21, has sanctioned the leave without pay. Now, your lordship, what happened, your lordship? Why this revisit? Because, your lordship, when this order was passed, my lord, whoever was holding the office passed this order. Whether all the matters were revisited or not, my lord, that is not known to the present incumbent. Well, what
may not be known, but once the
why,
records are there.
why, my lord? Let me submit why. Now, your lordship, this petitioner, again, in 2025, your lordship, this petitioner took medical leave for 3-4 days.
Not petitioner. Private respondent.
The private respondent. The teacher took leave for 4 days medical leave. And when he went to join, after taking the leave, when he went to join the school in 2025, my lord, that is in June 2025, your lordship, he was not allowed to join. So, my lord, he made an application and he made an application before the board. See, the school is not allowing me to join, and your lordship, board also received a letter from the DI to consider how this medical leave of the petitioner to be considered. So, my lord, board gave a hearing to the school authority, the private respondent, and the DI. So, my lord, in the course of hearing, my lord, this details has come out regarding the order passed by the Honorable Court. Now, my lord, what is the order of the Honorable Court, my lord? Kindly, lordship, kindly come to the order of the Honorable Court. My lord, the order was passed on 13th December 2012. The first order, where your lordship, what Honorable Court directed, my lord, the second paragraph I am reading, your lordship, page 22. It is alleged that after his recovery, he went to join the school, but the headmaster of the said school did not allow him to join. The learned appearing for the school submits that the aforesaid allegation, he further submits that the school petitioner shall be allowed to join, provided fitness. Now, your lordship, what is the order? In view of the above, the petitioner shall go to the school on or before 21st December 2012 and shall submit his fitness certificate issued by the registered medical petitioner. The school authority shall allow him to join. So, the direction of the court was to allow the petitioner to join. That is back in
subject to.
Well, I'm coming. In 2012, the school did not allow him to join. Thereafter,
there was no medical fitness.
No, there was. It reflects from the order of the court itself, your lordship, the contempt petition.
The court considered the contempt and recorded his date of joining.
No, my lord, may I? My lord, kindly, there are two orders of contempt, my lord, one at page 24. My lord, page 24, first, second, third, fourth paragraph. Through the plain, and simple reading of the direction would suggest such an interpretation to be taken, but if the order is read in its entirety, the meaning can be attributed to the said paragraph is that the school authorities shall allow the petitioner to join the service, provided he submits a fitness certificate. However, this court feels that the authorities should allow the petitioner to join the post, as the medical certificate appended to this contempt application is clear and explicit. The petitioner is directed to join the post on or before 3rd June 2014 without insisting for further production of the fitness certificates or the prior sanction regularizing the leave by the appropriate authority. So, why they didn't allow him to join? As because there was no regularization of leave. System is first he will join.
Why will you go to that stage? The court has considered, the court has taken note of the fact that the petitioner joined in June 2014.
But what your lordship?
Who are you to say?
2012, when there was a direction of the court to allow the petitioner to join, the school authority did not. Thereafter, the contempt was filed as because he was not allowed to join, the contempt was filed. Now, the next page, your lordship, the order of the final order of the contempt proceeding, your lordship, page 26. My lord, may I? By order dated 13 December 12, passed in WP number such and such, the petitioner was directed to go to school on or before 20 December and shall be
listen. If the court
in spite
did
of my
not,
second paragraph, in
I
spite
will
of
not
submission.
go into all these things. It was the court's order. The court felt that there was no contempt. It is the court who felt that there was no contempt.
I am not deciding upon the contempt. Why?
Are exceeding the jurisdiction. The court did not permit you to revisit the issue.
Well, I am not revisiting.
How could you change the order which was there in 18 in 2025 and say that
why?
he was
Because when the hearing was taken in 2025, in presence of the authorities came that the court in 2012 directed the school to allow him to join, but the school did not. So
and it was brought to the notice of the court that there is contempt and court did not find so. Why will you open it?
No, my lord.
It was an absolute open and shut case.
No, court directed, my lord. Can't see. Maybe the contempt was dropped, but my lord,
what does it mean? That the court did not find that the court's order was violated. This is what the
that is only the last reading, your lordship. But my lord, kindly second paragraph, in spite of submission of fitness certificate issued, did not allow. As because the school authority, in spite of the order of the court in 2012, the school authority did not allow the petitioner to join, your lordship.
And you will take steps.
That is the reason, your lordship.
That is the reason the court could have taken note of that the petitioner, that the employee was not allowed to join despite court order. Court did not find so.
No, my lord, court found, your lordship.
Despite that, the court did not pass any order.
No.
Then
no,
why should you?
That as because you have already been allowed to join in 2014, therefore no contempt. But
admittedly, the period of absence was there. The period of absence remains. Why will you open it?
No, my lord.
Somebody who was not there in service for any reason, for medical reason or whatever reason.
This ground because it was not the fault of the petitioner from 2012. That is the only reason.
You could have left it to the discretion of the court without taking it on your shoulder, whether it was whose fault or not.
The court held, my lord, he was not allowed to join. My lord, that is the only reason. There is no other.
Court did not permit you. Did the court permit you to revisit? You could have
and that board was not a party. Board was not a party in any of the proceedings.
The court did not feel it necessary to direct the board or any of the authorities to look into it. So you could not have revisited it. Yes. Is this the only reason?
Lordship, because there was a direction of the court.
My lord, kindly see the representation dated 25th of June 2012.
You admit that you were not there?
My lord,
you were on leave.
My lord, may I just submit? My lord, I was not allowed to join. Kindly just see page 28.
Did you obtain any order from the court?
Yes, my lord.
To permit you to join and to regularize whatever is there with pay? With pay.
My lord.
Regularization has been allowed, but without pay. Whether you'll get pay, whether you'll not get pay. You did not serve.
My lord, that was left to the authority to decide. My lord, kindly sees the order which was passed in the writ petition. My lord. Page 24, my lord. That is my lord, page 22.
22 order. Whatever was the order was taken up
the above.
You cannot reopen it.
In view of the above, the petitioner shall go to
the school. You cannot reopen it. You just cannot reopen it. It has been, a contempt was filed, the contempt stood disposed. You could not have reopened it. Anything else to say?
Even in the contempt, my lord, it was...
Was any leave granted?
Leave was, my lord...
No leave was granted to take up the issue. There was no leave granted to the board to revisit the issue after so many days. Suppose this 25th 2025 incident of absence would not have happened. There was no occasion for the board to go back to 2022 or 2012's issue. True? Then, now the authority over there is in your favor, and that is the reason you want to get it done. No, sir.
An opportunity of hearing, my lord.
No, it cannot be done. 2018, when it was without pay, did you challenge that?
No.
You accepted it. What does this mean? You were not aggrieved. Now somehow you could manipulate. And that is the reason you want to do it. The order passed by the President. Ad hoc committee, West Bengal Board of Secondary Education, on 21st August 2025. Revisiting the order of the Honorable Court dated 6th May 2024, passed in এখানে WPC লেখা আছে, এটা কি সি হবে? WPCRC
page 24.
WPCRC হবে, হ্যাঁ সি আছে, CRC 120, 22, page number 24 in WP 17768 of 2022, ঠিক আছে? Is impugned in the instant case. Stop. The writ petition has been filed by the school. Allegation is that the period of leave of the petitioner was regularized by the West Bengal Board of Secondary Education.
Page 21.
Way back on 8th March 2018, by clearly mentioning that the absence period of the petitioner from 21st October 2011 to 1st June 2014 shall be treated as leave without pay as per the leave rules. ঠিক আছে? The petitioner, no, not the petitioner, the teacher, being the private respondent herein, accepted the fact of approval of leave without pay and did not challenge the same. Stuff. In 2025, a representation was filed by the employee, by the teacher, in response to which the board revisited the entire issue and rescinded the order which was passed in the year 2014 by directing that the said period should be treated as leave spent on duty, leave with pay spent on duty. Stop. Paragraph. It appears that the court vide order dated 13th December 2012 was pleased to direct. 13th December 2012 in WP page 22 such and such. এখানে হচ্ছে private respondent versus the school বা the state. দেখে নেবেন একটুখানি, কি করে দেখবেন? আচ্ছা, directed that the teacher shall go to the school on or before 21st December 2012 and submit his fitness certificate issued by a registered medical practitioner. The school shall allow the teacher to join subject to regularization of the leave by the appropriate authority. Stop. As the teacher was not allowed to join the school despite production of a medical fitness certificate, an application for contempt was filed by the teacher. Stop. The said contempt application was taken up for consideration by the court on 6th May 2014. Stop. The court directed the school to permit the teacher to join on or before 3rd June 2014 without insisting for further production of fitness certificate, as the medical certificate was already appended to the application for contempt. Stop. The contempt application stood disposed of without granting any further leave either to the school or to the board to revisit the issue of regularization of the leave for the period when the teacher did not join the school. Stop. Paragraph. The learned counsel representing the board in support of the impugned order submits that though there is no leave or direction passed by the court permitting revisiting the issue, the same was reopened on the representation filed by the teacher. Stop. Paragraph. The aforesaid submission of the board cannot be accepted at all. Stop. Once an issue has been decided by the court and the board, in compliance thereof, considered the prayer for regularization of the leave, had passed order in the year 2018 by holding that the period of absence shall be treated as leave without pay, the board exceeded its jurisdiction and misdirected itself by revisiting and reopening the entire issue. Stop. The same is contrary to law and contrary to the order passed by the Honorable Court. Stop. Next, in view of the above, the impugned order dated 21st August 2025 cannot be treated to be a valid one. Stop. The issue in question was already decided by the board on 8th March 2018. Stop. The parties have acted in accordance with the same. Stop. Next. The impugned order stands set aside. The writ petition stands allowed.
Grateful. Great.
My lord, item number 70, my lord, I'm applying for the state, my lord. I just missed out, my lord. Can you record my appearance for the state? Item number 70.
কি হয়েছে?
70. For the state.
Petitioner ছিল over. But you were not there at the time of call.
I was just missed out. I was just coming. I was on the way, my lord.
You could have intimated some of your friends. The proceedings are being live streamed, so everybody can see that you were not there.
My lord, can you record my appearance for the
This is not magic. That if you are not there, your appearance will be reflected in the order sheet.
No, I apologize, my lord. I admit it. It is my fault, my lord. I was just.
Bring your other side. Bring your other side. I'll see. What a passover matter আছে.
Yes, I am for the.
Dismissed তো নয়?
Dismissal has been dismissed.
কিসের জন্য?
Dismissal has been dismissed.
But dismissed on merits, not on default. Then dismissed on merit, you bring your other side, I'll record your prayer. She should know that somebody is there. Otherwise, she'll come and blame the court that nobody was there. How can the name be recorded? Give a phone call to her. Come back. I'll record. Dekhi, Passover. What do you mean to say? The matter is not in the list.
Item number 74 is called on, but the item number is 49.
Yes, 49 passed over.
How can the matter be called if it is not there in the list? I do not have any special affinity towards this matter. No, the matter is there in the list. Yes.
Yes, Lordship, kindly come to page 33.
33. How did you make the calculation of the family income of the petitioner?
Here, Lordship, 60% of the Lordship family pension. Okay, Lordship. Other income, Lordship, not mentioned in the other income. I am disclosed the other income.
Yes.
No, other income is the.
Other income is a cultivation.
No.
No, nothing.
Lordship, I am disclosing.
All right, please come.
Direct I am disclosing.
In the.
আরে সেটা তো ভিডিও থেকে তুলে দিয়েছে তুমি দেখেছো? হ্যাঁ।
The decision of.
I have no source, no
the District Inspector of School Secondary Education, South 24 Parganas, dated 16th August 2022. Holding that the petitioner would not be entitled to compassionate appointment on the ground of a sufficient family income is impugned in the instant writ petition. Stop. Learned advocate representing the state respondents is directed to revert with the calculation of family income of the petitioner, which was taken into consideration for deciding the prayer of the petitioner. When? 2 weeks? Released 18 তারিখ 18th.
Every service be kept to the record.
Service is taken under.
Every service kept to the
My lord, item number 65. Yesterday, this honorable court considered me for my medical exigency, my lord. I just come to late, my lord. Item number 65, my lord.
Today's list?
Yes, my lord.
Huh.
Yes, my lord. Today list, my lord.
Today it has been dismissed for default. You were not there?
My lord, for few minutes late, my lord. Yesterday I was in medical. Yeah.
আজকে not today করে দিন।
But here not 130 lordship compared to 70 and
She's coming? Bring her at 2 o'clock.
215 lordship.
I'll go back to my chamber and come back. It'll take time. Y'all take your lunch and come. Take your lunch.
Grateful, my lord.
Item number 70, your lordship. Other side, my lord.
Petitioner, ma'am. Ma'am,
Mira, mira.
7. Thank you, ma'am.
Your Lordship, I am below the peace. Your Lordship, I am below the petitioner in this matter, Your Lordship.
Yes.
Lordship, I am audible, Your Lordship?
Very much visible and audible.
Your Lordship, I am led by Mr. Shogoto Mitru. He has not come to the court, Your Lordship. I am praying for not today in this matter, Your Lordship.
Where are you?
Your Lordship, I am in the doctor's clinic, Your Lordship, because I am not coming. My leg is not suitable for walk, Your Lordship. Your Lordship, I am below the peace. Your Lordship, I am below the petitioner in this matter, Your Lordship.
Are you seeking adjournment only for the day?
Your Lordship, I am.
Echo হচ্ছে।
Lord, I am appearing in item number 73, my lord. I'm sorry for my learned friend, my lord. My lord, in item number 73, my lord, Mr. Shogoto Mitra is appearing for the petitioner, my lord. My lord, I am seeking, my lord, 1 week time, my lord.
1 week? All right. Accommodation has been
On
sought
the-
for on behalf
My lord,
of the
as
learned
he is
advocate
not here, my
representing
lord,
the
he is out
petitioner.
of town, my lord.
Stop.
So, lordship, I am seeking 1 week time, my lord.
Release the matter for further consideration on 24th November.
Deeply obliged, my lord.
Grateful. Made pleasure, Your Lordship. Now for the petition. My lord, this is my application, my lord, which has been made for transfer, which has been made, my lord, on the ground of distance, my lord. In fact, and it has been made offline in
What is
prescribed
the
form.
stage now?
My lord, this has been made before the school authority, my lord. The school did not grant the NOC, and my lord, it is kept with the school itself. My lord, now, if I request your lordship to see page number 21 once. My lord, page number 21 is my application.
Is the school a party?
Yes, my lord, it is. 21 is my application.
Anybody representing the school?
I have served upon them and they are already received.
21 is your representation.
Yes, my lord, it is a forwarding letter, your lordship will see.
But then there is a specific format within which you are required to...
24.
Did you...
Yes, but it was a forwarding letter, so that the
Right.
prescribed performance is annexed to the
Please come.
forwarding letter. So I'll just request my
The petitioner's application seeking transfer
may I just
is pending consideration at the end of the school authority. Achha, on the for transfer on the ground of distance. school. Stop. The none represents the school. Stop. Affidavit of service is taken on record. Stop. The instant writ petition accordingly stands disposed of by directing the school to take a decision on the application made by the petitioner seeking transfer in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Stop. In the event the petitioner's application is allowed, comma, then the school shall take necessary consequential steps in the matter, strictly in terms of the applicable rules. Writ petition stands disposed.
And may I just request only one thing here? That what happens here, the petitioner before your lordship is a teacher of Sanskrit, of the and it is a single post. Naturally, it is a single teacher. So, my lord, I just request your lordship, unless, my lord, because this has been, my lord, the categorical finding of this honorable court that school cannot deny the NOC for a transfer. So, in that event,
stage has not yet
this is why I just beseech your lordship, my lord, it is not lying in the hand of the school to deny my application.
Very
so
well.
You have to forward.
Well, you
so
don't know whether they'll forward, not forward. What is the explanation? Let us not jump steps.
In that event, if I could just request your lordship once again, I can come back after, my lord, once again giving an opportunity to the school.
Come back with a fresh writ petition. Next.
As your lordship, please. Grateful, man.
আচ্ছা একটা লাইন লিখে দিন তো, the fate of the application shall be made known to the petitioner.
Grateful.
Yes. Prayer.
75, I'm for the petitioner.
Yes.
The petitioner, being an assistant teacher, was appointed as teacher in charge by the managing committee of the school in the year 2018. I tell you, what happened in this case. Since 2018, he was functioning as teacher in charge of the said school. A complaint was lodged against the teacher in charge, against some of the two teachers, by the teacher in charge, disturbing him to discharge his duty as teacher in charge. My lord, onwards your lordship will find 33 several complaints was lodged, my lord, against those two teachers before the DI, before the board, other authorities. My lord, your lordship kindly see. Also, my lord, complaint was lodged, my lord, to the local police station. My lord, all on a sudden, my lord, the petitioners, my lord, your lordship will find page 33, 18 January 2025. My lord, he was prevented, my lord, to discharge his duty as teacher in charge. And my
so
lord,
right now you have been
I tell your lordship, my lord,
out and somebody else have been directed to take over charge.
My lord, he moved a writ petition before this honorable court because against the my lord, not functioning as teacher in charge. Page 52, your lordship kindly see.
Yes.
Court, my lord, after your lordship kindly, my lord, go through the order. My lord, the court permit the petitioner to resume his duty, and my lord, the DI also, my lord, was directed to act, my lord, to ensure that the petitioners, my lord, can function, my lord, as teacher in charge. My lord, in compliance of the order dated 30th April to 2025, my lord, the petitioner was allowed by the DI of schools to
resume the duty of teacher in charge. Yes.
My lord, during the pendency of the writ petition, immediately after compliance of the order of this honorable court by the DI, you also kindly see this order was passed by the DI in terms of the directions of this honorable court on 23rd May 2025. That, my lord, in terms of the order, administrator was directed to permit the petitioner to resume his duty. This has, my lord, I have received this, my lord, later on. After this writ petition was pending, DI has complied with. I resume my duty. Immediately after that, my lord, the DI has instructed, your lordship kindly see, that is under challenge, page
59.
23rd May, 26th August 2025, DI instructed that the administrator to remove the petitioner from the post of teacher in charge and to appoint, my lord, those persons who my lord, was, my lord, the complaint against me. My lord, this is, my lord, if there is any complaint, if there is any my lord, the defalcation or misconduct, let them proceed, my lord, the initiate proceedings. And DI is not the authority, my lord, my lord, the appoint, my lord, the teacher in charge. The managing committee is the sole authority.
Order passed by the District Inspector of Schools, Secondary Education, South 24 Parganas, directing removal of the petitioner from the post of teacher in charge of the subject school and consequentially appointing one Sri Brojen Haldar as teacher in charge is impugned in the instant writ petition. Stop. Is the private respondent served?
Yes, yes.
You are there? What has happened to your hand? Huh? Fell down. Road accident. Red road. Where were you? In the bike? Motorcycle? You were riding? Pillion or riding? Behind. Pillion rider. Now fractured. Nine and 10 you are there. Has Wakalatnama been filed?
No, madam.
Verbal instruction. File Wakalatnama. Input in the instant writ petition. ठीक है. The District Inspector of School, Secondary Education, South 24 Parganas is directed to file a report on affidavit disclosing facts and reasons for removing the teacher in charge. Now, for removing the petitioner who was serving as the teacher in charge and appointing the private respondent number 9 in his place. Stop. The private respondent number 9 is also directed to file an affidavit disclosing his stand. Stop. The affidavit shall be prepared and circulated by 25th November. Released on 9th of December. It will be open for the petitioner to file an exception to the affidavit of the respondents.
The immediate service be kept on.
Service is taken on record. Leave granted to the learned advocate representing the respondent numbers 9 and 10 to file Wakalatnama in the department. When? When will you file?
By Friday.
By this week? By 7th November.
Well, at 76, I am for the petitioner. It is as that of item number 68, HRA, House Rent Allowance. But I am praying, let it be next week, your lordship pass similar order so that I can bring that order also.
All right.
Kore debe, dispose of korbe.
There is a judgment by my bench also.
Yes, yes. Today your lordship was similar.
No, this was an order, but then I have prepared a judgment when I was sitting in courtroom number 24. You can find that also. Achha. On the prayer of the learned advocate for the petitioner, release the matter for further consideration on 11th.
Well, affidavit of service with
service is taken on record.
Well, I am for the petitioner, my lord. The affidavit of service, my lord. The matter, my lord, related to the higher scale of pay covered by the special bench judgment, my lord. The petitioner, my lord, before joining, he completed part 1 exam.
Where is the representation? 59?
Page 64 is the last representation, my lord. Through the learned advocate, my lord.
No, but then 59 also, August 14, achha.
59 also is, my lord, the
same thing.
Through the school authority, my lord.
To the district inspector. Achha, thik hai, 64. The petitioner prays for higher scale of pay on সকালে কি একটা নিয়েছিলেন higher scale of pay on enhancement of his educational qualification. Stop. The petitioner relies on the judgment delivered by the Honorable Special Bench of this court on 7th February 2024 in the matter of in a batch of writ petitions, one of which is Utpal Kanti Koron, page 66 e dekhun, versus State of West Bengal in WPA 9921 of 2007, page 66. ঠিক আছে? The petitioner submits that his case will be covered by the ratio laid down in the aforesaid judgment. Step. A representation from the petitioner. Now, on behalf of the petitioner, seeking higher scale of pay is pending consideration at the end of the District Inspector of Schools Secondary Education, Baras, and not 24 Parganas. Stop. Without entering into the merit of the same, the instant writ petition stands disposed of by directing the aforesaid respondent to consider and dispose of the petitioner's prayer strictly in accordance with law, in line with the judgment mentioned herein above, after giving the petitioner a reasonable opportunity of hearing. At the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Step. If the prayer of the petitioner is allowed, comma, the necessary remedial steps shall be taken. Learned advocate for the petitioner is directed to forward a copy of the legal representation along with all supporting documents, page 64, at the time of communicating the order of the court.
They have passed, but they have waited for up to 14 years.
Reject their claim. 78. Commission. All right. Yes.
I am also challenging the validity of these rules. The specific prayer has not been made.
Then specific prayer is required to be made?
Yes, I think that's the criteria.
What will you do? File amendment, or you want to withdraw this and file fresh?
Let me withdraw this because liberty to file.
Already filed in yesterday I mentioned this three matter.
এটা তো অন্য কোনো আছে, এটা তো নেই।
গ্রুপ সিডিও আছে,
সেখানে ভাইরাস চ্যালেঞ্জ করা আছে।
হ্যাঁ ভাইরাস চ্যালেঞ্জ,
এটাই তো নেই, এটা তো লিখ করতে হবে।
এইটা না আমাকে গতকাল
লিবার্টি টু উইথড্র এন্ড ফাইল অ্যাপ্লাই।
Then its senior counsel submits the senior counsel representing the petitioner submits upon instruction that there are certain inherent defects in the instant writ petition. Stop. Prayer has been made to permit the petitioners to withdraw the same and to file fresh petition on the self-same cause of action. Prayer allowed.
The virus, there are other 3 writ petitions which are supposed to be in the list today.
Dismissed as withdrawn. Liberty to file afresh on the self-same cause of action on proper and better particulars. Yes.
But there are other 3 petitions which are challenging the virus. Is not in the list. We'll let it be listed.
It will be listed. It was mentioned yesterday.
But
it will be listed.
Listing date but not came in the list. That's why.
আজ এগুলো লিস্টে দিয়ে দেবেন তো, কালকে দিয়ে দিন, পরশু দিন লিস্টে থেকে দেবেন। Serve notice, the other side should be there. All right, Friday.
Already one of the data and you inform about it.
কালকে ফাইল পরশু ফাইল করে দাও, শুক্রবার দিন হবে একসাথে।
সেই বুঝছি।
শুক্রবার দিন আসবে কিন্তু মামলাগুলো।
79 I am for the petitioner.
79
I am for the petitioner.
Yes.
Petitioner pair for transfer on distance ground, my lord. Page 20
consideration.
And also school issue NOC forwarded to the DI. Pending before the DI.
The petitioner's prayer seeking transfer on distance ground is pending consideration at the end of the District Inspector of Schools. Which place? Secondary Education, Purva Mendipur. Stop. Without entering into the merit of the said application, the instant writ petition is disposed of by directing the District Inspector of Schools, Secondary Education, Purva Mendipur, to take a decision on the application of the petitioner in accordance with the relevant rules at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. If the prayer of the petitioner is allowed, comma, the necessary consequential steps shall be taken by the DI. Stop. Disposed.
Affidavit service kept on.
Yes.
Not 80, my lord. I am for the petitioner, my lord. This is my affidavit of service, my lord. My lord, this is the second round of writ petition, my lord. My lord, the petitioner is working.
Page 45.
Yes.
My lord, last three lines. In view of the above, Commission cannot issue recommendation for transfer in favor of you for the school mentioned. However, school may submit fresh choice under section 6(4)(d) for prevailing general transfer rules. My lord, subsequently, petitioner made an application, my lord, opting another school, my lord, next page. That is pending. My lord, kindly direct the school.
What is page 52?
Page 52, my lord.
Sorry, my lord, page 45.
52 is the rejection of my prayer on the ground
Yes.
that the seat has been vacancy has been reserved for the second SLST candidate.
Right.
My lord, in this, my lord, the backdrop of the matter is that, my lord, petitioner's earlier medical health checkup was made. Therein also it was considered. Thereafter, we preferred the writ petition since our prayer was not considered. Subsequently, my lord, the Honorable Justice Sogato Bhattacharya, my lord, directed the petitioner to go and approach fresh medical checkup. Thereafter, my lord, my name was again considered. Thereafter, I obtained an RTI information.
What is the position of the second SLST?
My lord, second SLST examination, my lord, completed, my lord. Result will be declared probably on 7th.
All right. But then the vacancy is an indicative one. Why will it not be? Petitioner will not be accommodated over there.
Authority is, my lord, changed from the DI to, my lord, the board. Now centralized roster system has brought into by the government of West Bengal. So, my lord, from District Inspector of School, vacancies are forwarded to the West Bengal Board of Secondary Education. Board maintaining the entire roster. And board, my lord, in consultation with the Education Department.
Don't tell me all these things. The claim of the petitioner arose earlier. The vacancy is an indicative one. Let this be
Page 41
given to the petitioner. The petitioner be accommodated over here.
They are marked for the second SLST.
Yes.
Then it cannot be.
Why it cannot be?
Because, my lord,
it is an indicative vacancy.
Notified for, it is reserved for second SLST.
You have to accommodate the petitioner somewhere.
Then, my lord, yes, my lord, kindly direct the petitioner to opt some other school.
How he'll opt? He stays in A place and he'll opt for a B place. He will opt for schools close to A.
Then, my lord, kindly direct the Secretary School Service Commission to, my lord, give a hearing and
no. Acha, very well. Who is maintaining all details of the school? The board?
The board and
the DI. State, you are there? Acha, ठीक है. The petitioner, the application of the petitioner seeking transfer stood rejected as the petitioner cannot be considered conclusively as the vacancy as the preferred school has been included in the indicative vacancy for the second SLST within bracket 80, 2025. Step. From the documents annexed to the writ petition, it appears that on 2 occasions, the authority could not accommodate the petitioner in the preferred schools by the petition indicated by the petitioner. Stop. Next. learned advocate representing the state is directed to produce the list of schools having vacancy where the vacancy close to the residence of the petitioner where she can be accommodated. Let this list be prepared and handed over to the learned advocate for the petitioner by 24th November. Release the matter for further consideration on 26th of November. Service is taken on record.
Grateful to your lordship.
Lordship, kindly grant a short partial.
Lordship, no, I'm here. I'm here.
Yes.
Am I audible, my lord?
Yes, I can hear you.
Yes, Lordship. The only difficulty is yesterday I have received three of the petition which was sent to the private respondent. That has came back, Lordship. The affidavit in service is with me, my lord. Lordship, can it be
tell me
taken
what
up?
your case is?
Lordship, the case is I am the first wife of the private respondent, Lordship. He is a high school teacher. Now, Lordship, what happened? While having the spouse living, he has conducted another marriage by suppressing the entire facts. Now, Lordship, Lordship, what is now my prayer is, it is twofold. First, Lordship, kindly take Lordship of.
Did you raise any objection before the authority for including the name of the second wife?
Yes, yes, Lordship. I have made a detailed representation in this regard, and they have also forwarded on one communication, Lordship. Lordship, this is page number 57. This is an RTI reply. Shayuntoni Janamidda Chaudhuri is the nominee. He is the second wife. This is the RTI reply which is given by the school. That is 57.
My lord, my humble clarification of lordship, my lord, since he made a representation and my lord has to decide it which one is correct. Being a pension sanction conflict, the issue decide the issue.
The petitioner alleges that the petitioner is the wife. The petitioner claims to be the wife of one নামটা লিখে দেবেন তো RAJJOYTI Midda Chaudhuri cost title থেকে দেখে নেবেন who is a school teacher. Stuff. Allegation is that her husband has contacted a second marriage with the private respondent, namely Shayantoni Jana Midda Chaudhuri, and incorporated her name as nominee in the official records. Stuff. The petitioner submits that the second marriage is illegal and the name of the private respondent ought to be deleted from the records of her husband. Stuff. A written objection by the petitioner has been forwarded to the District Inspector of Schools, which is alleged to be kept pending. Paragraph. The none represents the private respondents. Stop. As it appears that the issue in question is pending consideration at the end of the District Inspector of Schools. Accordingly, the aforesaid respondent is directed to consider the representation filed by the petitioner strictly in accordance with law after giving reasonable opportunity of hearing to the petitioner, the teacher, and the private respondent,
as well as the school authority.
And the school authority. Stop. Next. The if the petitioner is able to convince the aforesaid respondent with factual evidence of her marriage, the necessary steps shall be taken by the aforesaid authority. Stop. It is made clear that the District Inspector of Schools shall not enter or decide the factum of marriage and will take a decision on the basis of records and documents produced before him. Stuff. If there is any dispute with regard to the factum of marriage, the parties shall be relegated to the competent civil forum for declaration of their respective rights. Stop. A decision shall be taken by the DI at the earliest, but positively within a period of 12 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to all the parties. Disposed.
Grateful, Lordship.
Allegations against DI.
Great.
As the writ petition is being disposed of without calling for any affidavits, the allegations made in the writ petition are deemed not to have been admitted by the respondents.
Grateful, Lordship.
Lord, I am for the petition, Lord. This is evidence service, Lord. Lord, the matter relates to Lord mutual transfer, Lord, by the petitioners, Lord, to the respective Lord. Post is Lord same, Lord category same.
What is the stage of the transfer application?
Lord transfer application is pending. There is no steps.
Stage. Is it before the school authority?
School authority. School.
Both. Well, petitioner has to apply?
Apply in the pro forma.
Yes.
Online. But petitioner made a requirement.
Is the online one open?
Yes, now it's open for the mutual transfer.
Mutual transfer, it's open. All right. Yes.
Page 25.
Is
Page 25 is the
25 and 37. The same district. This is in the same district.
Yes, obviously.
This is the same district, my lord. Only, my lord, DI Puram Mindapur. My lord, page 25 and page 37, both representations.
What is 37?
37 is the representation of the, my lord, petition number 2.
Oh, acha. The petitioners seek mutual transfer.
My lord.
Stop. Their application seeking transfer is pending consideration before the District Inspector of Schools, Secondary Education, Purva Mendipur. Stop paragraph. Without entering into the merit of the said application, the instant writ petition stands disposed of by directing the DI, SE, Purva Mendipur to take a decision in the matter in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Whatever is required to be done will be done. The state is here.
Same DI, same district.
Achha. Necessary consequential steps shall be taken by the authority in the event the application of the petitioner is allowed. Post service taken on record.
Evidence service kept to the record.
I am for the petition. This is CPF to GPA barrier. I have corrected.
You have a copy of the
draft
convention order?
Yes, my
lord. Have you mentioned the date?
Yes, my lord.
Correctly mentioned?
Yes, my lord. Widow is the petitioner.
Widow is the petitioner. Pradeep. Disposed.
Grateful. My lord, same CPF to GP.
All right.
Petitioner himself, my lord.
Petitioner himself.
Yes.
All right. Disposed.
Grateful, my lord. My 85, my for the petition. My petitioner is working as an assistant teacher in a government-sponsored school, my lord. My petitioner has lost his job, my lord, pursuant to the order of the Honorable Supreme Court. In my lord, the first SLST case, my lord, all the inter-selection process has been cancelled, my lord. Thereafter, my lord, the petitioner participated in the second SLST for the post of assistant teacher in class 9, 10 and 11, 12. In
as per the recruitment rule, my lord, the candidate who is working in a government-sponsored school and government-aided school is entitled to get the proportionate marks out of total marks of 10. But in the online application in respect of a post of assistant teacher in classes, my lord, the 11, 12, my lord, petitioner could not mention his past experience, my lord.
Could not mention. Why?
But due to technical glitch, my lord. In 9-10, my lord, insofar as 9-10, my lord, we have mentioned, my lord. But admittedly, my lord, I am working, my lord, and nobody will be prejudiced, my lord. I could not mention, my lord, my past experience. That is
there was a window given to you for rectification.
not with regard to, my lord, the experience, my lord.
Oh, date of birth.
Yes, my lord. Yes, my lord.
What is to be done here? Yes. Obtained orders.
But admittedly, I am working, my lord.
But then overnight, what relief can they give to you?
But only, my lord, at the time after interview, if I come within the zone of consideration, my past experience may be considered, my lord. Since admittedly, I am
verify records and
yes, my
see
lord.
whether
Yes, my lord.
No, because I understand if this window is given by the court, then several such candidates will come up, and then it will be difficult for the authority to maintain the each and every stage. It has to be rectified.
4 to 5 days result has been published. So difficulty there are
But interview has not been done, my lord. My interview has not been done, my lord. They will conduct the verification process, my
Tell
lord.
me, submission is that everything took place in June or July, whatever. Why are you coming so late? You knew that you could not submit proper details.
But the several representation was made, my lord. But before the authorities, my lord.
Please show.
But the 15th September, the email was sent to the
September, from June, July, what were you doing?
But the kindly sees, my lord, the September, 15 September as well as 16, my lord.
Again, September prior there too? Nothing.
But the interview, but the written examination was held on 14 September as well as 7 September.
It is not a matter of examination. The application.
Yes, but I was under
last
impression.
date of filing the application was when?
But the last date of application was 21st
July.
Yes, madam.
Then
But only, madam, nobody will be prejudiced, madam.
It's not a matter of prejudice. It's a matter of giving advantage to a candidate who could not put in the proper details.
But admittedly, I am working, my lord.
Maybe.
But only at the time of verification, my lord. Nothing will, my lord, they will not prejudice. But in the
petitioner.
But in the identical matter, my lord, Honorable Coordinator Bench has also directed.
Let me see. And what is the date of the order?
23rd September.
In our form, there was a confusion. The form required the candidate to answer whether they were working under the
state
of government of West Bengal or not.
State
There is confusion which is recorded as paragraph 4 of the form.
All right. There is a prayer for, there is an order only for consideration of your representation.
Yes, my lord. That they will
suffice.
Let them consider.
Very well.
Kindly.
If you are happy with
consideration, I am working, my lord. Admitted.
Where is the representation?
My lord, page 69, my lord. And 70 is my email.
15th of September. The petition.
But I have already lost my job, my lord. Well, kindly consider, my lord.
No sympathy. It was done in terms of court's order.
Yes, ma'am.
So it cannot be done.
Yes, my lord. But
one of her applications she has applied.
Yes, my lord. In that, madam.
In 9-10.
Yes, my lord. In 11-12, I could not mention.
Yes.
But kindly, my lord.
Achha. Liguntu, the petitioner participated in the first SLST examination 2016. Stop. The entire selection process stood nullified by the Honorable Supreme Court. Stop. Pursuant to the advertisement published by the authority, the petitioner has applied afresh. Stop. The petitioner being an in-service candidate, would be entitled to certain marks in the next selection test. Stop. Petitioner submits that the in-service experience was mentioned by the petitioner in her application for getting the job for application for selection in respect of classes 9 and 10, but in respect of classes 11 and 12, comma, the in-service experience could not be recorded because of technical glitches. Stop. Admittedly, the last date of filing the application form expired long back on 21st July 2025. Stop. The petitioner has filed an application before the application, a representation before the chairman of the West Bengal School Service Commission on 15th September 2025 to take into consideration her past experience. Stop. They said request made by the petitioner is pending consideration till date. Stop. Without entering into the merit of the prayer made by the petitioner, the instant writ petition stands disposed of by directing the Commission to take into consideration the request made by the petitioner in accordance with law and in line with the order passed by the Honorable Supreme Court in this regard. At the earliest, but positively within a period of 4 weeks from the date of communication of this order, the recent order shall be passed and communicated to the petitioner immediately thereafter. It will be open for the authority to verify records to ascertain the averment made by the petitioner. Next.
Since the result has not yet been published, this opportunity is provided because after the publication of results, the consideration of representation is futile.
Let matters come. We can dismiss it also.
Right.
Yes, 86. Yes.
Whether the service rendered by the part-time teachers in substantive post should count towards weightage.
All right.
That's the question in the ensuing selection process
All
of
right.
2025. Now, 10% added.
Is anybody standing in your way?
At the commission, probably.
Probably.
Oh.
The respondents have any is the stand of the authority made known to you?
Not yet.
Why are you apprehending that they will not take into consideration your service as part-time teacher?
That we had been repeatedly pursuing with them.
Yes.
As my learned friend has already expressed, as a council of the state, that we are standing on the way. That the view has been expressed by the officers. We made with the representation to know.
You all made the application.
We made the applications disclosing our stand as having experience. Now we made representation as to whether this should be considered or not, because the definition of teacher does not make a distinction between a part-time teacher and a whole-time teacher. And
let them reject, then only you can come up with this is a premature petition.
There is a representation at 175. Kindly fix a time period for this so that we can come back in the second round.
This will give rise to complications.
This will not. I have a right to know. I have a right to know my.
Why?
That can also use.
Yes. State government has communicated a list of emergency law candidates who, apart from those unpaid teachers, were working in substantive. These petitioners are not working in substantive.
What does this substantive post mean?
It has been sanctioned by authorization of finance. We have explained that in our academic note. That's why we are file a report within 7 days.
Very well.
Please come. The petitioners participated in the second SLST for recruitment of assistant teachers 2025 in class level 9 and 10 and 11 and 12. Stop. The petitioners have the past experience of teaching as part-time teachers in secondary level. Stop. They seek weightage of marks for their past experience in service. Stop. They apprehend that the authority will not provide them the required weightage. Stop. Paragraph. The respondents are directed to file a report disclosing their stand apropos the grievance of the petitioners by 2 weeks করে দিন আজকে 4 তো 18 exception if any may be filed by the petitioner 1 week 25th released on 2nd of December. Service is taken on record. 18 petitioners.
প্রত্যেকটা মামলায়
একটু দেখে নেবেন তো কোর্ট ফিসটা আছে কিনা in case it is not there then deficit court fees to be paid. Yes.
May I seek your lordship's leave to use a supplementary affidavit disclosing documents as regards their working. I have served a copy on my learned friends.
Very well. Supplementary affidavit filed in court is taken on record.
86.
Yes. 87.
Yes.
87. 87.
I appear on behalf of that I have served a copy of petition duty only.
All right.
I need some time to take instruction from the Bhubaneswar office of the.
All right. Just let me hear what he has to say.
My lord, matter relating to re-evaluation of answer script of our daughter, class 10 level under CBSE board. Lord, if kindly straightway come to page 42. My lord, page 42, question number 6A, Roman 1. My lord, Lordship kindly question number 6A, Roman 1. My lord, kindly have a look into the my lord marks awarded 1, Roman 2, 1, Roman 3, 1. And next page, page 43. My lord, Roman 4, 1 plus 1, 2. Got it, my lord?
No, 42 you showed me.
1 plus 1 plus 1.
Yes.
Then page 43.
43.
6, 4. 6, Roman 4. Right hand
1
side.
plus 1, 2.
1, 2. Then, my lord, 2 plus 3, 5. Total 5. But in the right hand side, mistakenly written 2. Got it, my lord? Question 6, right hand side. That portion.
Question 6, left hand side.
2. After summation, it should be 5.
It is 5.
But here written 2.
Which page you are in?
Page 42. Then
42, 2.
42.
Achha.
That portion 2. And my tabulation, my lord, page 30. No, page 31. Page 31, kindly come to that question paper, question number 6. Got it, my lord? That portion, kindly have a look into 6. 6, question number 6, 2.
Page
31.
31. Yes.
My lord, question number 6.
Question number 6.
2. What is, my lord?
Question number 6, 2.
2. My lord.
All right. Question number 6. Here you got
42.
1, 2, 3.
4, 5.
3 and 5.
5.
It was marked 2.
8, 1, 1, 1. 1, 1, 1. 3 আর এই 3 আর 2 5 ডান দিকে লিখলো বাঁ দিকে লিখলো 2 আর ট্যাবুলেশনও 2 লিখেছে
Page 43.
43.
Top.
Continuation of question number 6, Roman 4.
Roman 4. How many marks is there in Roman 4?
Roman 4, 2. 1 plus 1, 2.
How many total marks in question number 4?
Question number 4, how
You
many?
have the question paper?
Question
because I can see 4. How many marks are there in question number 4?
question পেপারটা আমাদের
even if I take it to be one question with 1 mark, then also I think the candidate will get 2 more marks, isn't it? Please come. The petitioner. Who is the petitioner? Parents. The son or daughter?
Daughter.
The petitioner's daughter appeared in the CBSE examination. Stop. The petitioner has alleged that the marks on receipt of the information under the Right to Information Act, the petitioners were provided with the photocopy of the answer scripts of the petitioner, wherefrom there appears to be error in calculation of marks. Not calculation, summation of marks. Summation of marks. Or better you write addition of marks. ঠিক আছে? Reference has been drawn at pages 42 and 43, question number 6. Stop. It has been submitted that only 2 marks has been awarded. 2 marks have been awarded. In the said question, the petitioner would be entitled to 3 more marks. Will that make a lot of difference?
98, 94, 98 out of 100. Good student, my lord.
All right.
Instead of allegation, my lord, submission, CBSE board, my lord.
আচ্ছা ঠিক আছে, সাবমিশন অ্যালিগেশন না করে সাবমিশন করবেন, ঠিক আছে? Learned advocate representing the board seeks time to revert with instruction. When? Next Tuesday, Monday, Tuesday? Tuesday. Released next Tuesday. 11 তারিখ. Yes, yes. Service is taken on record.
Evidence of service kept in the record.
CBSE Council, please put in your appearance. All right. All right.
I am appealing for the petitioner. This is the affidavit service. The petitioner participated in the written test in SLST second, and he could not write the experience, means prior teaching experience. He could not submit. It is in page.
Why you could not submit?
Because can you come to page 50, my lord? There was written that only in government. He was working in Jawahar Navodaya Vidyalaya for 6 years around.
Yes.
So it was written that in page 50, my lord.
Page 50?
50, my lord. Are you working as an assistant teacher in aided or sponsored school under West Bengal government? So he was under central government in Jawahar Navodaya Vidyalaya. So that work he could not do. So he is praying for availing that benefit of prior teaching experience.
All right. There was an order showed to me just now.
It is in 51, page 51.
Did you approach the authority?
No, my lord, he is now in Shillong for 1.5 years. So his hometown is in Purulia. So he could not.
He is approaching the court, my lord, after 3 months.
Right, my lord.
After the judgment has been delivered, order has been delivered.
The mercy petition for he can apply and.
Approval, can I say?
What is your stand with regard to this?
Stand is that experience will
Count, irrespective of the fact whether state government sponsored or central government. Teacher is a teacher.
Stand is this: if the teacher is appointed against sanction.
All right.
Sanction post.
All right.
Experience will count.
Counted.
Irrespective of fact whether is the employee of the Delhi government, UP government, that is the.
Even the private schools?
No, government.
All government schools.
Government or government sponsored?
All right, government sponsored, government aided, not private schools. All right.
Now, this Vidyalaya is of course central government.
Central.
The question is just can I suggest in the appeal code also
In against this order?
Not against similar order.
All right.
Let him make a representation by tomorrow, because the 6th is the date because we are running against the time. We will consider his case, but he has to produce the documents that he is having an experience against the sanction, and let him appear on 6th. No further notice.
6th for what?
This November.
For what?
For consideration of this case. Let him make the representation by tomorrow.
Huh? Tomorrow is a holiday, so
Online.
Because here at Shillong, Miller.
Online.
Okay.
Yes.
Or you give it to the WhatsApp to my junior, I will forward it. That much I can do it.
Make application online.
Okay.
All right.
Yes.
And let him come on 6th at 11 o'clock.
He'll come directly,
yes,
without any.
No, this is the notice I am giving. Order, kindly record with the order itself. Because all matters
has been fixed.
6th on 6th. We are having the difficulty. Result will be published, and then the verification will be made within 7 days. We have to complete. The 31st December we have to finish. With this verification, before the verification.
Can he appear on 7th?
7th.
6th. 6th is
7th, my lord.
No, the date is fixed on 6th.
The appeal code has fixed 6th.
Appeal code has fixed.
I will inform.
I am helping you.
Yes, I will
understand this.
Because and bring all documents to show that you have been engaged against a sanctioned vacancy.
My lord, can I give this one?
What is
notification of Jawahar Navodaya?
Nobody is disputing.
Okay.
But you have to show documents in support of your experience.
Regarding sanction post.
Sanction post. Have you followed? The petitioner participated in the second state level selection test, 2025. Stop. He could not submit he however failed to indicate the details of his past experience. Stop. The petitioner claims that he is working in the school Jawahar Navodaya Vidyalaya. ঠিক আছে? Prayer has been made to take into consideration the past experience, take into consideration his past experience as teacher. Stop. The Learned Counsel representing the commission submits that as the petitioner did not fill in the details of his past experience, accordingly, the same cannot be counted. Stop. However, it has been submitted that if the petitioner applies before the commission by tomorrow, within bracket 5th November, and appears before the authority on Secretary of the West Bengal Central School Service Commission on 6th November 2025 at 11 a.m. with all documents to show that he served as a teacher in the subject school against a sanctioned vacancy, then the commission shall take into consideration the past experience of the petitioner. ঠিক আছে? The petitioner is accordingly granted leave to make proper application online by tomorrow. And That is an internal arrangement that I will not record. Because this will come up next time and it will be shown. Why will you trouble your junior? He will be enjoying somewhere else and then this application will pop up. লিখুন তো and he is directed to কি বললো tomorrow হলো আর 6 তারিখে by 11 he should report before the secretary of the commission. ঠিক আছে? The commission will take into consideration the prayer of the petitioner. And if all documents are found to be in order, then the marks allotted for past experience be awarded to the petitioner. Disposed.
May I request one order to be uploaded today?
It will be uploaded today. You make the application and as it has been requested, please forward a copy and 6th he should be there.
Right.
How he's going to come, the court doesn't know.
My lord.
He?